Welcome to the West Virginia Legislature on the West Virginia Channel. I'm Beth Voorhees. Here's a live look in the House of Delegates chamber at the state capitol in Charleston. Up for passage on the House floor today, House Bill 2083, increasing the felony criminal penalties for exposing children to methamphetamine manufacturing. House Bill 2123, making the West Virginia schools for the deaf and blind eligible to participate in any and all funding administered or distributed by the West Virginia School Building Authority. House Bill 2486, providing that when a party's health condition is at issue in a civil action, medical records and releases for medical information may be requested and required without court order. House Bill 2542, relating to public higher education personnel, and House Bill 2585, creating felony crime of conducting financial transactions involving proceeds of criminal activity. Those bills are up for debate, explanation, and passage on the House floor today. Two bills on second reading, the floor amendment stage, House Bill 2420, providing that the State Board of Education may delegate its Medicaid provider status and subsequent reimbursement to regional educational service agencies or county boards. And House Bill 2506, relating to the permit limit calculations and allowing overlapping mixing zones for calculating permit limits for drinking water criteria. This bill was the subject of a public hearing yesterday. It's a controversial bill involving water quality. And on first reading in the House, just making their way through the calendar process, House Bill 2329, prohibiting the production, manufacture, or possession of fentanyl. House Bill 2620, the West Virginia Drug Overdose Monitoring Act. House Bill 2646, terminating the Women's Commission and discontinue its functions. And House Bill 2648, increasing penalties for manufacturing or transportation of a controlled substance in the presence of a minor. Those bills are on first reading on the House floor today. We will bring you today's House floor session live. We are recording the Senate floor session, and we'll bring you that as soon as the House floor session has ended. And we'll wait here for House Speaker Tim Armstead to gavel in the floor session. And the Senate chamber's cameras are active. We'll go to whichever floor gavels in first this morning. Among the bills up for passage in the Senate today, Senate Bill 125, authorizing the DHHR to promulgate legislative rules. Senate Bill 214, adopting Uniform Electronic Legal Material Act. Senate Bill 321, reporting requirements of employee information to the CPRB, that's the Consolidated Public Retirement Board. And Senate Bill 426, repealing DNR legislative rule on litter control grant program. Those bills are up for debate and passage in the Senate today.
House will be in order. All those not having privileges to the floor will please vacate the chamber. Members and guests will please rise as we are led in prayer today by Rabbi Ureki, who is the guest of Delegate Pushkin.
Almighty God, thank you for this day. Thank you for this country and thank you for this state. We are so grateful to you for the beauty found in West Virginia, both its natural resources, its breathtaking landscape, and its decent and warm citizens. West Virginians are some of the kindest, gentlest, and giving people in this country. We thank you, God, for them, and we pray that you bless them and watch over all our brave, dedicated, good, and hardworking men and women. Dear God, bless the men and women who are in this chamber, dedicated and loyal servants of our state, who have been entrusted with taking on the monumental challenges we face as West Virginians. May you grant the leaders of this chamber wisdom and forbearance. May they proceed today and until the end of this session with justice, compassion, courage, strength. May they work together, have respect for each other, and realize we are all here to help the people of West Virginia who desperately need them to not be enemies, but brothers and sisters united to help our state. Tough decisions lie ahead, but may they find common ground, common cause, common purpose. May you help them see opportunities to join in unity, moments to reach across the aisle and find an outstretched arm, and give them all the inspiration to better our state and make it shine in the months and years ahead. Amen.
Members and guests will please remain standing as we're led in the Pledge of Allegiance by the gentleman from the 37th, Delegate Pushkin.
Thank you, Mr. Speaker. Would the members and guests please join me in honoring our nation's flag. I pledge
pledge
allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Reading of the journal.
Journal of the House of Delegates, Charleston, Monday, February 27th, 2017.
Chair recognizes the lady from the 51st, Douglas Fleshauer.
Thank you, Mr. Speaker. In the words of my cousin from Grant County, Mr. Speaker, I ask unanimous consent that the further reading of the journal be dispensed with and that it be approved as having been read.
The lady channeling the gentleman from the 54th asks unanimous consent that further reading of the journal be dispensed with and it be approved as having been read. Is there objection? Chair hears none. Journal is approved as having been read. Gentleman from the 58th.
Thank you very much, Mr. Speaker. Ladies and gentlemen of the House, we have a citation presentation recognizing the state AA champion softball team from Chapmanville High School. To accept the citation, we have the championship team and coaches. Escorting our guests in the Chamber are Delegates Rodigario, Phillips, Maynard, and Eldridge.
Clerk, please read the citation.
Whereas, this past season, the Lady Tigers softball team, led by Coach Ronnie Uten, achieved a 33-6 record and won the 2016 AA State Championship. The Lady Tigers captured the State AA State Championship with a 10-0 win over James Monroe at Jackson Memorial Park, Vienna. The Lady Tigers had to fight out of the losers bracket and win 3 games to take the school's 6th state title. Chapmanville beat Petersburg 4-0 and James Monroe 12-4 earlier in the day. Coach Ronnie Uten has 36 years of coaching softball for Chapmanville Regional High School. His overall coaching record is 680-165, which is an 80.4 winning percentage. He has had only one losing season in 2013, and he has had 6 state championships: 1994, 2004, 2007, 2009, 2010, and 2016. Coach Uten has been named State Coach of the Year 3 times, is the 2016 National Coach of the Year in softball, and has been head coach in football, junior and senior high, head coach for girls basketball, junior and senior high, and an assistant for boys high school basketball. Coach Ronnie Uten is assisted by Barb Uten, Dave Elkins, John Carter, and D.A. Harless. Therefore, the House of Delegates of the West Virginia Legislature hereby recognizes and congratulates head coach Ronnie Uten and the 2016 West Virginia AA State Champion Chapmanville Regional High School Lady Tigers softball team.
House, please be at ease a moment while I greet our guests and present the citation.
I'm sorry.
John for the 58th.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, today we have a citation presentation recognizing the State A champion volleyball team from East Hardy High School. To accept the citation, we have the championship team and coaching staff. Escorting our guests into the chambers is Delegate Spinagle and A. Evans.
Clerk, please read the citation.
Whereas this past season, the East Hardy Lady Cougar volleyball team made history by winning the West Virginia Class Single A State Championship with a come-from-behind 3-2 victory over perennial volleyball power Wirt County. East Hardy started its march to victory by beating Paw Paw and Moorfield in the sectional tournament. The team advanced to regional play against Doddridge County and Moorfield, where the Cougars did not allow a team to win a single set. East Hardy played its first game of the state tournament against Ritchie County, where the Cougars found themselves behind early, with Ritchie taking the first set. After settling into the game, East Hardy won the next 3 sets to advance to the semifinal round against the tournament favorite Williamstown. Against Williamstown, the Cougars found their rhythm early and cruised to a 3-0 victory and a spot in the state title game against Wirt County, the team who knocked East Hardy out of the tournament in the opening round in 2015. In the title game against Wirt County, East Hardy fell behind early, but found their footing and adjusted in Game 3 to the attacks that were coming from the Wirt County front line. After the East Hardy rally, Wirt County battled in Game 4 and had a match point when East Hardy rallied for 3 straight points and forced a Game 5. East Hardy raced ahead to start Game 5 and held on to win the first girls' state championship in the history of Hardy County. East Hardy finished the season with a record 31-6-2 and stayed undefeated against Class A competition. The team was given the royal treatment with an escort starting at the county line from the Hardy County Sheriff's Deputies, Matthias Baker Fire Department, Matthias Baker Rescue Squad, Wardensville Rescue Squad, and many fans and well-wishers. The players addressed the fans during a welcome home party at the school. The House of Delegates of the West Virginia Legislature hereby recognizes and congratulates head coach Marcia Hahn and the 2016 West Virginia Class A state champion East Hardy Lady Cougar volleyball team.
House, please be at ease a moment while I greet our guests and present the citation.
You're watching the West Virginia Legislature on the West Virginia Channel. This is the House floor session live. We will bring you today's Senate session once the House session is over.
Gentleman from the 58th.
Thank you very much, Mr. Speaker. Ladies and gentlemen of the House, we have a citation presentation recognizing All-American football player Joseph Hayes. To accept the citation, we have Mr. Hayes and his family members. Escorting our guests into the chamber is Delegate E. Evans.
Clerk, please read the citation.
Whereas Joseph Hayes IV is a senior at Mount View High School in McDowell County, where he is a member of the football, baseball, and basketball teams. Joseph is a member of Trinity Missionary Baptist Church, president of Flat Top Baptist Association Youth, a member of Health Sciences and Technology Academy, sponsored through WVU, and a member of AFT West Virginia Reconnecting McDowell. During the summer of 2016, Joseph attended West Virginia Boys State. Joseph was nominated twice for and won WVVA Play of the Week, won Player of the Week in Week 10. In the fall of 2016, Joseph was interviewed on National Sports Report Football Radio, was nominated to the National All-American Bowl Game, was nominated for Football Player of the Year, and was Offensive Player of the Game twice. Joseph was named Second-Team All-State. Therefore, the House of Delegates of the West Virginia Legislature hereby recognizes Joseph Hayes IV and directs this citation be presented.
House, please be at ease a moment while I greet our guests and present the citation. Introduction of guests. Gentleman from the 28th, Doug Cooper.
Thank you. The president of the Monroe County Farm Bureau, Mr. Jim Gore, if he would stand up. And I would like to make this comment about Mr. Gore before we have a round of applause. He has pioneered a couple of things in keeping track of some heirloom plants that he's been recognized in this whole country for. But besides all of that, he runs a very efficient greenhouse. He's been a good advisor to me for the last 4 going on 5 years. And he's also a retired high school principal and school teacher. So he's had a full life, and I thank him for being here today. Let's please make him welcome.
Gentleman from the 42nd, Delegate Amber.
Thank you, Mr. Speaker. I would like to introduce from Greenbrier County for Delegate Baldwin and myself 2 Canterbury's today. I hope that the one is a member of the Greenbrier County Farm Bureau, and honest to Pete, I believe he is the most prolific recruiter for the Farm Bureau that's in the state of West Virginia. Denny Canterbury, I don't know if he's made the audience or not, but the other Canterbury that is here is my friend and yours, 8-time delegate from the 42nd District, Greenbrier Summers, Monroe County. We have with us in the North Gallery, Denny Canterbury. Denny, Ray.
John from 62nd, Delegate Overton.
Thank you, Mr. Speaker. On behalf of the Eastern Panhandle from Berkeley County's delegation, from the far reaches of the state, from the Eastern Panhandle, from Berkeley County. We have Leadership Berkeley, Tina Combs, the Chamber Executive Director, and her group of students that are learning more about the state. Would the members of Leadership Berkeley please rise while the House makes them welcome?
John from the 13th, Doug Higginbotham.
Thank you, Mr. Speaker. Today, one of the pages from my district is joining us. Brooke Godby attends Poca Middle School and is an 8th grader, and she's also joined by her mother, Luann Godby. So if the House could please make them feel very welcome.
John from the 14th, Doug Butler.
Thank you, Mr. Speaker. Joining us today from Hurricane Middle School and High School with the PAGE program, we have McKinley Morgan, accompanied by his mom, Stephanie Morgan, if you guys would stand, and also Jacob Kidd and his mom, Cynthia. Would the House please welcome them?
Lady from the 52nd, Doug Sapo.
Thank you, Mr. Speaker. Today we have in the North Gallery Janet Gregg. She's here with the Farm Bureau. If she would stand and everybody make her welcome. Thank you.
John from the 1st, Doug McGeehan.
Thank you, Mr. Speaker. Today I have a couple of friends with me in the North Gallery. I have Carrie and her son in 3rd grade, Chance. And Chance has got quite the brain on him. So if the House could please make these two individuals very welcome.
John from the 10th, Doug Chris.
Thank you. Thank you, Mr. Speaker. On behalf of the Wood County and Wirt County delegation, I'd like to introduce Dave Lawson and his wife, President of the Wood County Farm Bureau. Please make them welcome.
The gentleman from the 12th, Doug Westfall.
Thank you, Mr. Speaker. We have pages with us today from Ripley Middle School. As I call your name, will you please stand and recognize you? And then the parents are, I think, in the South Gallery, but Ian Roach, Samuel Cox, Davis Haynes, Morgan Kimball, Alex Vance, Hunter Harper, Caitlin Lawrence, Avery Harris, and last but not least, my granddaughter, Zoe Casto, and her mother, one of my daughters in the South Gallery. Will you please make them feel welcome? Thank you.
John from the 35th, Doug Bird.
Thank you, Mr. Speaker. On behalf of myself, Delegates Capito, Nelson, and Lane, we have a very great advocate for AARP in the South Gallery, Miss Jane Marks. Would you please stand? Would the House make her feel welcome?
John from the 20th, Doug Markham.
Thank you, Mr. Speaker. Paging today from Mingo County, we have Sidney Young, Kenneth Justice, David Jarvis, and Evan Maynard, and they're escorted to the Capitol by Teresa Maynard and Joe Maynard. If the House will give them a warm welcome, thank you guys for coming, and stand up and be welcome. Thank you.
John from the 42nd, Doug Baldwin.
Thank you, Mr. Speaker. In addition to my friends at Canterbury's who are here, the Delegate Ambler has introduced, I'd like to introduce my neighbor from Roncevert, here with the AARP and a retired educator, Mr. Danny Gray. Please make him feel welcome.
John from the 3rd, Doug Fluharty.
Thank you, Mr. Speaker. Along with Delegate Storch, I'd like to welcome a wheeling transplant in the South Gallery, Mr. Rich Sternstreet. Most of you know him. If he would stand in the House, make him feel welcome.
Lady from the 51st, Douglas Pleshire.
Thank you, Mr. Speaker. We have two representatives of AARP here today in the gallery to my right, Danny and Cheryl Beck. Would the House please make both of them welcome on behalf of the delegates from the 51st.
Lady from 16th, Douglas Miller.
Thank you, Mr. Speaker. Representing AARP from Lincoln County is Mr. Larry Bays. If you all would make him welcome, please.
John from the 48th, Douglas Miley.
Thank you, Mr. Speaker. On behalf of all of the delegates from Harrison County, we have joining us today Bob and Nellie Orsburn. They are down here volunteering for with AARP. If they would rise and allow the House to make you feel welcome.
John from the 5th, Douglas Pethel.
Thank you very much, Mr. Speaker. Today, ladies and gentlemen of the House in the South Gallery, I have some guests here with the Wetzel County Farm Bureau, Robin Yeager, and two students she homeschools, Brooklyn and Kiera. I'd ask they please stand and the House make them welcome. Thank you.
John from the 13th, Douglas Brewer.
Thank you, Mr. Speaker. On behalf of Delegate DeCerio and myself, in the South Gallery, I have the pleasure of introducing 8 of the hardest working electricians in the state, members of IBEW Local 968 in Parkersburg, West Virginia. Would the House please make them feel welcome?
John from the 4th, Douglas Farah.
Thank you, Mr. Speaker. Delegate Canistero and I from the 4th District have several guests here today. Representing Marshall County in the Farm Bureau Day today, we have Mike Mariner and Greg McGuire. Would they please stand and let the House make them welcome? And also, Mr. Speaker, we have from Marshall County, Mount Olivet, Our Lady of Peace 8th graders here today. And they are accompanied by their principal, Maureen Kerr, teacher Renee Schneid, and Father Doug on deck. If they would please stand and let the House make them welcome.
Lady from the 57th, Douglas Rowan.
Thank you, Mr. Speaker. From West Virginia's oldest county on Farm Bureau Day today, we have our County Commissioner, Dave Parker, and his wife, Jill. Would the House please give them a wild and wonderful West Virginia welcome?
John from the 58th, Douglas Coles.
Thank you, Mr. Speaker. Ladies and gentlemen, we've been joined by our Doctor of the Day today. In the back of the chamber, we have with us Dr. Kimberly Becker of Clendenin. If the House will make the doctor welcome.
Lady from the 3rd, Douglas Storch.
Thank you, Mr. Speaker. I had to wait a lot of years to get a sister, so I did when my brother married Maureen Kerr. So I just like my sister-in-law to stand up so the House can make her welcome.
John from the 25th, Douglas Painter.
Thank you, Mr. Speaker. It's my pleasure to introduce 4 members of the Mercer County Farm Bureau. I don't know which gallery they're sitting in, but if you're here, stand up and let everybody see you, and everybody give them a big thank you. The members are Harry and Barbara Wright, Shirley Miller, Josie Lester, and Paul and Nancy Canterbury. Stand up if you're here.
I also have 2 pages here today from Elkview Middle School. We have William Bourne and John Bourne. If they would stand in the House, make them welcome. Further introductions. Reports of standing committees.
Your Committee on Judiciary has had under consideration House Bill 2364, prohibiting electioneering within or near early voting locations during early voting periods, and House Bill 2619, Risk Management and Own Risk and Solvency Assessment Act. Reports back to committee substitute, therefore, with recommendation that the committee substitute do pass.
Report be received.
Your Committee on Education has had under consideration House Bill 2651, relating generally to standardized testing requirements for non-public schools. Reports back to committee substitute, therefore, with the recommendation that the committee substitute do pass.
Report be received.
Your Committee on Education has had under consideration House Bill 2373, authorizing school bus drivers trained in administration of epinephrine auto-injectors to administer auto-injectors. Reports the same back with amendment with recommendation that it do pass as amended, that it be referred to the Committee on Judiciary.
Report be received and the bill be referred to the Committee on the Judiciary.
Your Committee on Government Organization has had under consideration House Bill 2502, relating to reciprocity of occupational licenses with other states. Reports back to committee substitute, therefore, with the recommendation that the committee substitute do pass.
Report be received.
Your Committee on Government Organization has had under consideration House Bill 2343, requiring the state police to lease rather than buy vehicles if cost effective, and House Bill 2475, authorizing the tax commissioner to collect tax, interest, and penalties due and owing from payments to vendors and contractors from the auditor and other state, county, district, or municipal officers and agents. Reports the same back with amendment with recommendation that each do pass as amended, that they be referred to the Committee on Finance.
Report be received and the bills be referred to the Committee on Finance.
Your Committee on Government Organization has had under consideration House Bill 2630, authorizing the West Virginia Board of Medicine and the West Virginia Board of Osteopathic Medicine to share staff. Reports the same back with recommendation that it do pass.
Report be received.
Your Committee on Judiciary has had under consideration House Bill 2684, imposing penalties for repeat violations of the prohibition against driving under the influence on a suspended license. Reports the same back with the recommendation that it do pass.
Report be received. Reports of select committees. Messages from the executive. Messages from the Senate.
The Clerk of the Senate announces the passage by the Senate of Committee Substitute for Senate Bill 80, equalizing criminal penalty for entering without breaking regardless of time.
Message be received and the bill be referred to the Committee on the Judiciary.
The Senate has passed Senate Bill 164, relating to traffic regulations and special load limits.
Report be received and the bill be referred to the Committee on Roads and Transportation and then the Judiciary.
The Senate has passed Committee Substitute for Senate Bill 204, requiring persons appointed to fill vacancy by governor have same qualifications for vacated office and receive same compensation and expenses.
Message be received and the bill be referred to the Committee on Judiciary.
The Senate has passed Senate Bill 231, relating to State Board of Education and Medicaid-eligible children.
Message be received. Gentleman from the 58th.
Thank you, Mr. Speaker. This, on second reading on our calendar, is House Bill 2420, which is substantially similar to this SB 231 that's passed the Senate and come before us. Therefore, in order to sync the two up, Mr. Speaker, I ask unanimous consent to dispense with the committee reference. The bill be taken up for immediate consideration and read a first time.
Gentleman 58, asking consent to dispense with the committee reference. The bill be taken up for immediate consideration and read a first time. Is there objection? Chair hears none. Bill be read a first time. Clerk, please read the bill first time.
Senate Bill 231.
Bill be advanced.
The Senate has passed Senate Bill 330, relating to West Virginia Workplace Freedom Act.
Message be received. The bill be referred to Committee on Judiciary.
The Senate has passed Senate Bill 349, repealing outdated code related to Division of Corrections.
Message be received. The bill be referred to Committee on Government Organization. Resolutions. Petitions. Motions. Bills introduced.
House Bill 2726, authorizing home incarceration officers to arrest participants for violating the terms and conditions of his or her supervision with or without a court order.
Gentleman from the 58th.
Thank you, Mr. Speaker. I ask unanimous consent that further reading of bills introduced be dispensed with, and each bill be considered formally introduced and referred to the appropriate committee as listed on Chamber Automation System.
Gentleman 58 asks unanimous consent that further readings of bills introduced be dispensed with. Each bill be considered formally introduced and referred to the appropriate committees as indicated on the chamber automation system. Is there objection? Chair hears none. Each bill be considered formally introduced and so referred. Unfinished business. Bills on third reading.
Committee substitute for House Bill 2083, increasing the felony criminal penalties for exposing children to methamphetamine manufacturing.
Question before the House is the passage of the bill. The gentleman from the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. To the members, you'll see a series during this session of bills that passed either through the judiciary as a main reference or through the Committee on Prevention and Treatment of Substance Abuse, and then second reference to the judiciary, which focus on our drug addiction, drug trafficking problem. This is one of those, and these bills are designed either to strengthen penalties or to give our law enforcement additional tools to address this epidemic. House Bill 2083 did come from the Committee on Prevention and Treatment of Substance Abuse, passed that committee and came to the judiciary. It basically increases the penalty for manufacturing meth, okay? You know what I'm saying, meth, in the presence of a child. Under current law, it is a felony punishable by 1 to 5 years in prison, and the crime reads as follows. Any person 18 years of age or older who knowingly causes or permits a minor to be present in a location where meth is manufactured or attempted to be manufactured. In this bill, we increase the penalty from 2 to 10 years, or up to 2 to 10 years, from 1 to 5 years. In addition to increasing the penalty, the committee substitute also rewrites the existing statute to make clear that there is an enhanced penalty if a child suffers a serious bodily injury while being at a location where meth is being manufactured. The penalty does not change. It's still 3 to 15 years, but the statute has been rewritten to clean up the penalty language and to define the definition of serious bodily injury to be the same definition as is used in the child sexual offenses section of the code. Overall, the intent of this bill is to increase the penalty for those persons who cause or permit a child to be present at a location where meth is being manufactured. Mr. Speaker, I urge passage of the bill.
Are there other members desiring to speak to the passage of the bill? John from the first, Delegate McGee.
Thank you, Mr. Speaker. I'll be voting no just because these bills that are being rolled out from judiciary that are just imposing more and more crimes and more laws on the books are in the tradition of anything but Western civilization. They're in the tradition of Machiavelli, Hobbes, Rousseau, even Nietzsche. So I reject this line of thought. I'll be voting no.
Further members desiring to speak to the passage of the bill? Not the question for the House is the passage of the bill. Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, 98 ayes, 2 nays, no members absent not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 2083.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Further bills on third reading.
House Bill 2123, making the West Virginia Schools for the Deaf and Blind eligible to participate in any and all funding administered or distributed by the West Virginia School Building Authority.
Question before the House is the passage of the bill. The lady from the 57th, Delegate Rowan, to explain the bill.
Thank you, Mr. Speaker. The bill would amend the provisions of the West Virginia Code relating to the operation of the West Virginia School Building Authority. The bill would allow the West Virginia Schools for the Deaf and Blind to be eligible for funding it is currently ineligible for through the West Virginia School Building Authority. The bill also provides that the SBA may not require a local match from the schools, nor may it penalize the schools for not having a local match in its prioritization of projects it funds. I urge passage of the bill.
Are there other members desiring to speak to the passage of the bill? Gentleman from the 35th, Delegate Nelson.
Yes, thank you, Mr. Speaker, and I stand also in support of this bill and
do want to commend the gentlelady from the 57th for her fine work with what she does for the School of the Deaf and Blind, who will be here later, I guess, in March. For the membership, we had this bill the last 2 years. It passed out of this body unanimously. What this does is just allow the school and the deaf and the blind who reach out to needy children throughout this whole state to compete for some of the funds in the SBA, or the School Building Authority, that they issue annually to fund major improvements. I urge passage.
Further members desiring to speak to the passage of the bill? If not, the question before the House is the passage of the bill. All those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine. The gentleman from the third. If so, the clerk will close the machine and ascertain the result. On that question, 100 ayes, 0 nays, no members absent not voting. The majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
House Bill 2123.
Are there amendments to the title? Not title as read by the clerk will be and remain the title of the bill. Gentleman from the 58th.
Mr. Speaker, I move the bill be made effective from passage.
The gentleman from the 58th moves that the bill be made effective from passage. All those in favor of the gentleman's motion will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 100 ayes, 0 nays, no members absent not voting. 2/3 of the members elected having voted in the affirmative, I declare the bill effective from passage. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Further bills on third reading.
Committee substitute for House Bill 2486, providing that when a party's health condition is at issue in a civil action, medical records and releases for medical information may be requested and required without court order.
Question before the House is the passage of the bill. The gentleman from the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. House Bill 2486 relates to records that have been obtained by insurers in connection with insurance claims or civil litigation. And for those of you who were last year, this may sound familiar. We basically are picking up where we left off last session. It did generate some discussion. There were amendments on the Senate side and then over here. And basically, after some exchange of messages back and forth, the version died on the last night in the Senate before it could be considered. This particular bill provides that medical records and medical billing records obtained by insurers in connection with claims or civil litigation shall be confidentially maintained in accordance with state and federal law, including the provisions of the Code of State Rules, which is a rule from the Insurance Commissioner regarding privacy of consumer financial and health information. The bill also contains a provision that no additional restrictions or conditions may be imposed that contradict or are inconsistent with any applicable policy of insurance or the performance of insurance functions permitted or authorized by state and federal law. Finally, the bill requires the Insurance Commissioner to review the current provisions of the state rules and to propose new or modified rules to the extent that the Commissioner determines is necessary. That particular provision was added in the Senate last session and included in the bill to address the concerns of the Senate. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? The gentleman from the 60th, Delegate Wilson.
Thank you, Mr. Speaker. Will the gentleman yield?
The gentleman yield? Gentleman yields.
Yes.
Point of clarification, please. Is there any compulsory language in this bill? I've read it a couple of times. I can't find it. What I'm asking is, does it merely allow one party to request the medical records of the other, or does it allow them to compel them?
Well, the rules of civil procedure govern the obtaining of the records through civil litigation. All this bill does is address what happens after the records are obtained. It does not address how they are to be obtained.
Thank you, sir. Thank you, Mr. Speaker.
Further members desiring to speak to the passage of the bill. Gentleman from the 19th, Delegate Hicks.
Would the chair yield, please?
Gentleman yield. Gentleman continues to yield.
Yes.
As it stands now, the procedure is that if one objects to certain medical records being produced, the insurance carrier would have to file a petition with the court to mandate the production of those records. Is that correct?
Yes, this bill does not change the process for obtaining the records. It simply is focused on what happens after those records are obtained. But yes, you're correct. If there's
Okay.
a dispute over whether the record should be delivered, then the court would have to intervene.
Okay. And I'm not sure whether I understood you correctly, Chairman Schott. Are you saying that without court interference, that these records must be produced by the claimant?
No. Once again, maybe I didn't make myself clear. This bill solely focuses on what happens after the records are obtained. It does not change the process that's required now to obtain the records, nor does it change the process that is currently in place that regarding a dispute as to whether the records should be turned over to the insurance company.
Okay, so we're merely dealing with the admissibility of those records as opposed to production. Is that correct?
No, not the admissibility, but simply what the insurance company has to do with those records in terms of preserving confidentiality and so forth in accordance with federal and state law. Once again, the admissibility would be a decision for the court where these records would have be offered in evidence.
Okay, thank you. May I speak to the bill?
Gentleman may proceed.
As it stands, it's my understanding if there is a dispute, you must go to the court and let the court make that decision. I believe this bill provides the allowance of to obtain those records without that. And for that reason, I would oppose it. Thank you, Mr. Speaker.
Gentleman from the 20th, Douglas Markham.
Thank you, Mr. Speaker. Will the chairman yield?
Gentleman yield. Gentleman yields.
Thank you, Mr. Chairman. A couple questions about confidentiality. Is there any penalties provided for in this bill that would, if confidentiality is breached?
The bill basically refers to this federal and state law as well as the Code of Federal Regulations. So in response to your question, the bill is silent on that issue, but those penalties, adverse consequences, whatever you want to call it, would be contained in either the state law or federal law that addresses confidentiality. I think there's a specific provision in the state code that deals with confidentiality. So you would have to refer to those provisions in order to determine what penalties are available.
Okay, are you talking about HIPAA, the HIPAA laws that are in place?
Well, that certainly is one of the laws that would be implicated. That's a federal law that would be implicated, yes.
Okay. Mr. Chairman, do you know the penalties provided under HIPAA if there's a wrong disclosure of someone's medical records?
I'm sorry, I don't know. I don't have those at my fingertips, so I don't know. I know there are penalties in the statute. I just don't.
Would it surprise you to know that only the Department of Justice can enforce HIPAA violations?
I'm not surprised by much of anything these days.
And that there's no private cause of action if there's a violation of HIPAA. Would you agree with that?
If HIPAA would apply, then whatever is provided in the federal statute would govern. I'm sure there, as I said, there's also reference to state laws and there's reference to the state code of regulations, so state code of rules.
Okay, at the appropriate time, I'd like to speak to the bill.
Gentleman may proceed.
Thank you, Mr. Speaker. Ladies and gentlemen, this bill, from what we've heard the discussion today, the chairman told us it's going to be governed by HIPAA. For those of you that don't know, HIPAA has no self-authenticating provisions for the violation of HIPAA. Those cases are only handled by the Department of Justice, and they only apply to medical providers. So HIPAA does not apply to insurance agents and other entities that would have these records. And that's very concerning to me because there's no way to regulate what information would be disclosed by these agencies. Again, HIPAA, there's no private cause of action for HIPAA if there's a violation. Only the Department of Justice can do that against medical providers, nurses, doctors, or other types of groups that hold medical records. Therefore, this bill would allow the breach of confidentiality to numerous people when their certain conditions may not even be in question. One individual might go in for a broke leg and then 2 years later have a broke arm in a car wreck, and all this information comes out. I'm sure that ladies don't want to have information about the birth of one of their children come out in a case where they broke their leg in a car wreck. This is very overreaching. This is very complicated, but it's a simple way to fix this bill, and that's to eliminate it. I mean, the only way we're going to stop to protect confidentiality of individuals who are involved in a lawsuit or some type of civil action is to defeat this bill. I mean, I'm here to protect my constituents, protect my friends who are involved in similar types of cases. And I don't want all their medical records out for the last 30, 40 years because they filed suit on a broke arm or a broke leg in a car wreck. This bill has not been fully vetted, because if it was, we would have known about the issues with HIPAA. Again, HIPAA is only enforced by the Department of Justice, and there's no private cause of action against someone who wrongfully discloses medical information of another, other than, like I said, the Department of Justice. So for those reasons, Mr. Speaker, I'll be voting against this bill. And for my colleagues across the aisle, I'm sure your constituents would not be too happy to know their medical information can be disseminated across the internet or anywhere else if you vote for this bill. So I encourage a no vote on this. Thank you.
John for 39, Doug Walters.
Thank you, Mr. Speaker. In my business as an insurance agent, particularly in the area of health insurance, and many of you know I work with lawyers in the structured settlement business, I'm required to sign a HIPAA agreement with every insurance company that are in those markets so that I protect the data as we receive it in our office. We have to have it from the standpoint of helping claimants in a lawsuit, that if their age is shortened, their life expectancy is shortened because of their medical injuries, we can provide a better benefit for them. But those records are highly protected. We're required to shred them, and we have to sign as an agent a HIPAA agreement not to release that data. And our data only goes to medical doctors within the insurance market. So I just wanted to clarify that. I'm not taking issue with my friend from Mingo. I just wanted to make sure from an insurance standpoint what you know we have to go through. Thank you very much.
John from the 60th, Doug Wilson.
Thank you, Mr. Chairman. Mr. Speaker, will the chairman yield?
Gentleman yields.
Yes.
Thank you, sir. So I think we've established that this bill will not provide any further protections for the data. Is that correct?
I think what this bill does is make it clear that all of the protections that are available under state laws, federal laws, and our state code rules, our rules, apply when the records are delivered to the insurance company. So
Yes,
it's not a matter it takes anything away. If anything, this bill adds to the protections by making it absolutely clear that all of those rules apply to protect the confidentiality of those medical records.
Yes, sir. So it clarifies the existing regulations. Does it in any way add vulnerabilities to the system?
No, I think
Thank you, sir.
It certainly doesn't take anything away.
Thanks, sir. Thank you, Mr. Speaker.
John from the 20th, Doug Markham.
Thank you, Mr. Speaker. I'd have another question for the chairman. Could you explain to the body, Mr. Chairman, what those protections are? You say existing law. Well, we know federal law doesn't apply to protect anybody against the dissemination because that federal law is HIPAA, so that doesn't apply. What laws are you talking about that would protect someone's medical information if it was disseminated to someone else?
Well, there's a number of different laws, and I'm not prepared to give you all of the details, but the Graham-Riley federal law protects it. We have a statute in our state code that protects the confidentiality of records. I guess the real question is not what there is now, but the fact is what will we have if we don't pass this bill. This bill makes it absolutely sure that every protection that's available currently is available and in effect with respect to records that are once delivered over to an insurer. It does not subtract any protections that currently list. It makes it clear that those protections apply in that instance where those records are delivered. But Not passing this bill does not add anything. Passing this bill makes it clear that these protections all apply.
Those protections you're talking about, though, only apply to medical providers, not a third party.
Well, not every protection. Certainly HIPAA is limited in some respects to medical providers, but there are other provisions in the law, and I don't have it handy, but if you would check under confidentiality, there's a section in our code that deals with confidentiality that protects records. So this doesn't take anything away. It just clarifies that all of these protections are imposed on those records that are turned over to insurance companies.
Mr. Chairman, thank you. I would just respectfully disagree. It does not apply to third parties. Thank you.
John from 36, Delegate Rowe.
If the chairman would yield for a question.
Gentleman yield. Gentleman yields.
Yes.
As I understand it, HIPAA prevents disclosures to third parties, to other folks. Would an insurance company be able to, say, use the information in future claims or future eligibility? For example, if someone had a car accident and their medical records revealed that they had some very exotic disease, and then 10 years later they decided they'd apply for life insurance or something, would the insurance company be barred from using that information from the automobile accident in the eligibility determination for the health care policy?
All right. My understanding is that under our local rule, our code rule, this is Title 114, Series 57, licensees are not required to obtain an authorization to disclose non-public personal health information for the performance of the following insurance functions. So there is a section dealing with what insurance functions they can use them. Claims administration, claims adjustment and management, detection, investigation, and reporting of actual or potential fraud, misrepresentation of or criminal activity, underwriting, policy placement of insurance, and loss control. That is currently the law that's currently a rule that has the effect of law here in West Virginia. This provision that we're looking at, this bill, does not change that in any way.
Okay, but it says that once the insurance company has the information, they can use it in the future for underwriting purposes.
Yes.
So there's no limitation on the use.
That is the current law, regardless of what we do with this bill.
Right, but if that information is didacted, say plaintiff's counsel says we don't think that that's appropriate information about the disease in a car wreck case, we don't want that information to go to the insurance company. What this law would do is to say that that the order would automatically go forth unless objected to by plaintiff's counsel, and then it could be in effect used for underwriting. In other words, once the insurance company has the information, they can use it for any of those purposes.
And to the gentleman, this bill does not change any rights to resist a request for information that parties currently have. It doesn't change in any way the process for obtaining the medical records. Whatever you could do today to resist an effort to disclose information, you can do after this bill is passed. It doesn't change that. All it does is make clear that all of the laws governing confidentiality apply to those records once they're received.
Thank you, sir.
Are there other members desiring to speak to the passage of the bill? The gentleman from 27th wish to close debate. If not, the question for the House is the passage of the bill. Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 68 ayes, 31 nays, 1 member absent, not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 2486.
Are there amendments to the title? Not title as read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate. Request concurrence therein. Further bills on third reading.
Committee substitute for House Bill 2542 relating to public higher education personnel.
Question for the House is the passage of the bill. Gentleman from the 66, Delegate Espinosa, to explain the bill.
Thank you, Mr. Speaker. Mr. Speaker, the purpose of this bill is to empower institutions with more authority relating to personnel decisions on their campuses and to facilitate the implementation of contemporary programs and practices to reward and incentivize performance and enhance employee engagement. The bill makes personnel changes in 3 major areas. First, the bill redefines classified and non-classified employees and eliminates the current requirement that only 25% of employees may be designated as non-classified. For employees hired on or before July 1st, 2017, the bill provides that classified employees are full-time, non-faculty employees of an institution, unless the employee, A, is in a policy-making position, B, is considered critical to the institution, C, is a direct report to the president, or D, is involved in an IT job. For employees hired after July 1st, 2017, the standard would be based primarily on the definitions of exempt and non-exempt employees of the Federal Fair Labor Standards Act, also known as FLSA. Classified employees are those who do not meet the duties test for exempt status under FLSA. Non-classified employees are those who meet the duties test for exempt status under FLSA. In addition, non-classified employees are considered at will unless otherwise established by the action of the institution where employed. Secondly, the requirement for bumping and recall rights is eliminated from code. The bill provides that institutions are to develop rules for reductions in workforce after consultation with and 30 days notice to the applicable staff council. These reductions shall be based on A, documented job performance, B, skill set, C, seniority, or other factors as determined by the board. The bill further provides that institutions may provide a severance package for senior employees that are laid off. The bill does not impact any of the protections afforded to employees by various laws, such as Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, Title I of the Americans with Disabilities Act, and the West Virginia Human Rights Act. Third, the bill shifts the Higher Education Policy Commission's and Community and Technical College Council's role from one of centralized governance over the statewide human resources system to one of assisting institutions. The bill eliminates human resources review by the HEPC and CTCC. It also eliminates the higher education classified employee salary schedule and outdated associated requirements, and it eliminates provisions regarding implementation of the salary structure, as well as provisions prohibiting flexibility in human resources until the full funding of the salary schedule is met. The bill creates a new section which would authorize WVU, Marshall, and the Osteopathic School to develop their own classification and compensation system and promulgate rules therefore. Any other institution may develop their own system and rules by providing notice to the HEPC or the CTCC. In creating these systems, institutions are first required to consult with and give 30 days notice to applicable staff council. The bill sets forth the objectives of the rulemaking and stipulates that statutory definitions of classified and non-classified employees must remain the same. Performance evaluations and training must be included in the rules. The bill requires the rules to provide for an external review of human resources practices every 5 years and to include provisions that give staff council the opportunity to speak with external auditors before and after the review. In addition, the rules may provide for differential pay for employees who work different shifts, weekends, or holidays. Finally, management must meet with representatives of staff council at least quarterly to address implementation and any needed changes. The bill also creates a new section that would allow governing boards to adopt rules relating to faculty after consultation with and 30 days notice to the Faculty Senate. These rules would preempt any HEPC or CTCC rules which conflict. HEPC and CTCC rules will remain in effect to the extent an institution does not develop its own rules. The Chancellor's duty to review organization classification and compensation rules, as well as their power to reject or disapprove of those rules, is removed. Mandatory statutory provisions dictating the hiring of a human resources chancellor and staff at the HEPC are eliminated. the mandate that HEPC and CTCC hire an external vendor every 5th year to conduct a market salary study is removed and replaced by the requirement that they use workforce compensation data provided by Workforce West Virginia and other compensation data that is readily available from nationally recognized sources. Code provisions are further amended to clarify HEPC, CTCC, and institutional duties related to human resources to conform with the intent of this legislation. Mr. Speaker, this bill will empower our higher education institutions to fulfill their responsibility to the citizens of West Virginia, and particularly to our college and university students, to explore and implement any opportunity to maximize efficiency while maintaining high levels of productivity and service. Managing personnel decisions at the local institutional level is one way to significantly reduce operating expenses at the state level, while also recognizing the important role that higher education employees will play in solving the challenges that face our state. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? Gentleman from the 29th, good morning.
Thank you, Mr. Speaker, and thank you, ladies and gentlemen. I would take it that you probably heard enough from me yesterday. If we were to vote on that right now, I'd probably win a vote here. Yeah, I see. Yeah, you agree with me on that. But my colleague, the distinguished chair of education, read you a big, long list of what this bill does. If I may interpret that for you, it does away with all employee rights. Everything these people, these employees that have faithfully served our state have worked for to obtain and have abided by these regulations, it does away with it. We tried to amend it yesterday to get the right of recall. We couldn't even get the right of recall. I am amazed. And when we have met with those that are wanting the bill, we look for ways to compromise. Can we compromise? Can we help you achieve your goal without doing away with all employee rights? And we were told no. I think it's sad that we're so dug in that it's all or nothing, because it would have been easy for us to sit down, talked about it, reach a compromise that we could all vote for. But that wasn't on the table. It's all or nothing. We yanked the carpet out from under them, or nothing at all. So that's where we're at right now. I think it's the wrong thing to do. We need to treat the employees with dignity and respect, and just the right of recall. We couldn't even get that if they get displaced, that they would be recalled. That's a simple thing. Wasn't on the table. We can't do it. No compromise. All or nothing. I mentioned it yesterday, and I'll mention it again to you today. Would you like to be treated that way? Is that the way that you would want your children treated? They can be kicked to the curb? You spend years and years with an institution and you're no longer needed? Or there things change. I understand that situations can change and we need to have staff reduction. That's understandable. Unfortunate, but understandable. And before, they could have had the opportunity to be recalled to their jobs. Now they can't. I take this as another attack on working men and women. I ask you to reject this bill. And maybe, if you reject it, we can sit down and work out a compromise. Thank you.
John from the 26th, Doggett Evans.
Thank you, Mr. Speaker. I also
rise in opposition to this bill. You heard a list from the chairman, distinguished gentleman, of all the recourses that were not allowed. Nothing is allowed. As the gentleman from Raleigh County said, it's an all-in or nothing. I received an email from the president of the Faculty Senate, or the chair of the Faculty Senate at Marshall University, and they oppose it. We were told in committee that the higher education faculties and so forth would not be affected. I guess they're not, but they are in agreements with those that work at the college. It will be considered in this bill. Not only does the Faculty Senate oppose it, but the Staff Council opposes it. And of course, the Staff Council would be the very people that we're talking about. No one from those particular entities addressed the committee, only the makers of the bills and council. We didn't get to hear how they would be affected. Well, I think this is some of the most anti-worker legislation that we could put out there. We're simply telling the workers at these higher education institutions that their opinions don't matter. Mr. Speaker, I have so many concerns about this bill. I think what happens at higher education will eventually dwindle down to public education, and we'll see our public education employees faced with the same problems that we're proposing here today. For those and other reasons you've heard here today, Mr. Speaker, I would urge the members of this body to reject this bill. Thank you.
Further members desiring to speak before I recognize the gentleman from the 66th to close. The lady from the 51st, Douglas Fletcher.
Thank you, Mr. Speaker. I support many parts of this bill. I think that it's very good to get WVU and Marshall out from under the bureaucracy at the Higher Education Policy Commission, among other things. There was a lot of thought given to this bill, and there are many good parts to it. However, I can't support the changes to employee seniority. I trust the current leadership at WVU. Gordon Gee signed my law school diploma. Joyce McConnell and her husband Vince Travelli are close friends of mine. But I worry about future leaders. And the reason why is because seniority is something that everybody knows what it means. And we are taking that away in two very important places when you're going to be laid off, and actually we're taking away, as the gentleman from Raleigh mentioned, the right to recall altogether. Those two things have been in our law for years and years and decades, and they are going to be gone. A problem with taking away seniority is you allow subjectivity to creep in. And you also, what that includes is age discrimination. It gives authority to shed older, more expensive workers. People that work at WVU and Marshall that are my neighbors and my friends that have house payments and that have truck payments. A lot of people in our country and in our state are insecure right now, and the reason they're insecure is they're insecure about their jobs. This bill does not make them worry less. I'm also concerned about the process, and that was mentioned by the gentleman from Raleigh as well. This bill was rushed through, and sadly, it could have been crafted more carefully. I agree with the gentleman from Raleigh that we could have sat down with people and worked out compromises that would have been more fair to the employees. But that wasn't an option. I'm especially disappointed that none of the members of my delegation, Monongalia County, that are graduates of WVU, were consulted in advance and had an opportunity to weigh in and to help make this bill better. That's what I've learned how to do here, is try your best to make a bill better. And we didn't have a chance to do that. Now, I know that no one wants to lay anyone off, and WVU and Marshall have been, for years and years, have coped with enormous budget cuts and have succeeded in not laying people off. That's great. They should really be congratulated for scratching and clawing and raising lots and lots of money from outside sources to make that happen. However, Ronald Reagan said something that has been repeated many, many times: trust, but verify. And now, without the guide of seniority, which as I said, we all know what that means, it's going to be a lot harder to verify whether decisions about layoffs are fair. It's going to be a lot harder to know when someone doesn't get the right to recall at all, whether they say they could recall you, but we won't know because of seniority. They have lost that right. We won't know whether that person is going to be recalled or not. And I think it's more like our parents, not our sisters and our brothers, that this bill affects, because they've gotten longevity increases, and they're the ones that are going to be more expensive, and I guess, hopefully not, but maybe more expendable. So I'm sad that we're taking away something, seniority, when it's most important, and I hope I'm wrong, but for all these reasons, I'm voting no.
The gentleman from the 60th.
Speaker. Thank you, Mr. Speaker. I'm on the Education Committee. I'd like to address the idea that we did not give this bill due consideration. That's flat out false. We worked through it. We worked through every aspect of it. We amended it various times. As a matter of fact, I proposed an amendment which passed, which would actually require the schools to in place a counseling, and not counseling as in psychological counseling, but job performance counseling and evaluation system. Now, they already do this, but we've codified it. That's one issue. The next is that I have actually been laid off before from a steel mill I worked at in Texas. And when they got over their financial hump, they called me back. They didn't call me back because there was a requirement in law that they called me back. They called me back because I worked really hard and made myself a valuable employee. Now, I was not the oldest person around. I was not the most expensive person around. But I understand those considerations. But the thing is that when you are the most expensive employee around, the assumption is that you're that expensive because you are that valuable. If you maintain that value, once the company, once the organization has the resources to bring you back, they will bring you back because you're that valuable. They'll come out looking for you. Now, what we're talking about here is not removing anything from the schools other than a requirement that they perform this way. No one is saying they can't use seniority. All we're saying is we're not going to force them to. Now, that brings us to another issue. I've taught leadership for many years now, and I'll tell you that the only time you have any authority over anyone is when you have responsibility for them. If I remember correctly, our level of responsibility has been cut down to less than 20%. Okay, so we're less than 20% financially responsible for these institutions. Let's say we have less than 20% authority over them. So what we're saying is we have some bare minimum standards. You've got to treat your people right. You've got to maintain these standards. Other than that, we're going to let you do your job. On top of all of that, we have to remember what the purpose is for these institutions in the first place. Is the purpose to provide jobs for people, or is the purpose to provide a system for effective and efficient education? I would say that it's to provide education. We need to allow the people who do that on a regular basis to do that as effectively and as efficiently as possible. One of my colleagues over here mentioned that she trusts and supports the leadership of those institutions. Fantastic. Let's trust and support them and allow them to do their jobs. Thank you for your time, Mr. Speaker.
John from the 50th, Caputo.
Thank you very much, Mr. Speaker. I certainly rise today in opposition to what I think is one of the most mean-spirited pieces of legislation I've seen in quite some time. And I rise in opposition today, not foolishly thinking that I'm going to change any votes in this House or change the outcome of this bill, sadly. But I rise today because I think the folks that this affects needs a voice on this floor today. And I think those hardworking people at these higher ed institutions need to know what I believe is about to happen to them if and when this piece of legislation becomes law. You know, last night I had some discussions with the leadership of the AFL-CIO, and I wanted to know if they felt any concerns about this piece of legislation. And quite frankly, they do. They're concerned, as the gentleman said, that this will eventually reach into public education. This could set a precedent to reach into highways. It could set a precedent to reach into every part of government that we have worked so hard to create working standards for our hard-working employees. So they think the precedent is being set, and it goes way too far. But for those folks that work at these higher ed institutions, you know, I'm talking to you right now. I'm talking to you right now. Your pay scale is gone. It will be set by the administration, and they will determine what job gets what pay. Your seniority rights that you've spent maybe your entire adult life gaining, giving your loyal, hard-working day, every day for maybe 30 years, that should guarantee you some security on the job in the event of hard times, gone. And then the final blow, the one that I think is probably the most mean-spirited part of this entire bill that we discussed yesterday. If you get laid off, they don't even have to call you back. If you've been there 25, 30 years, you're 55 years old, that's all you've ever done was mop the floor or mow the grass, you worked hard, your back's wore out, they don't have to call you back. Now, I don't know how many folks in here ever had to find a job when they were 55 or 60, when all they'd done was work hard their whole life. It's tough. It's tough. And those folks deserve better treatment than what this bill is giving them. It's sad to think that we can do that to the folks that made West Virginia go for so many years. Now, you know, I know the lobbyists that are down here, and they're pushing for this bill, and they're getting paid to do a job, and I get that. But I'm sure those folks are getting paid a whole lot more than that guy that's mowing the grass is getting paid. And I'm sure they're getting paid a whole lot more than that guy who's mopping the floor is getting paid. But they're down here telling us things like this is contemporary. I'm not sure where that comes from. We got to move with the times. Well, I don't think treating employees badly is moving with the times. I'm sorry. I just can't see that. What they have created, and I've been working for a labor union for a long time, and I've organized workplaces that have the kind of systems that we're trying to create here. This is a buddy system, make no mistake about it. If you're in good with the boss or the administration, you will move up. If you're not, you're going to hang in limbo. And if you're one of those folks that get laid off and you're not in that clique, You all might be shaking your head over there, but you know I'm right. You're not going to get called back to work. And if you're that employee who maybe worked his way up to a $60,000 a year salary, they might just call a couple kids at $20,000 a year to replace you. It's not fair. It's not a union, non-union thing. It's not a business labor thing. It's a fairness issue. I think we all come down here to try to be fair to the people that we represent in our districts. You know, these institutions and their lobbyists, they want us to keep flowing money into these institutions. Let's keep flowing money into them, but they don't want us to have any say on how the employees are treated. They're trying to build an empire. Make no mistake about it. They're trying to build an empire. If you work for one of these higher ed institutions, I hope you see what they're trying to do to you as a loyal employee. I hope you're outraged, and I hope you express your outrage to the administration, because this bill has got to go across the hall. It's going to pass here today. There's no question about it. But it's going to go across the hall because it is on a fast track. But you still have time to call your representatives and express your outrage of how you're being treated for being a good, loyal employee for the state of West Virginia. Mr. Speaker, I would urge rejection. I would urge rejection, but more importantly, I think the folks back home need to know what's happening to them down here and what their representatives are about to do to them. Please vote no.
John from 35th, Doug Bird.
Thank you, Mr. Speaker. And much to your all's surprise, I actually was leaning toward voting for this bill. But I'm getting emails this morning that are contradictory to what a lot of things have been said on the floor today. And I appreciate the gentleman from the 60th comments about properly vetting this bill. And with this information that I've received this morning, I don't feel personally that I have had a chance now to properly vet this bill. So taking into your consideration and giving the fact that we have a pretty light calendar on third reading tomorrow, I'm going to move pursuant to Rule 53 that we lay over the bill to a day certain tomorrow and that it retain its place on the calendar. So I have a chance to talk to all these individuals from Marshall, WVU that seem not to be on the same page right now.
John from 35th to ask that the bill lie over to tomorrow. Moves that the bill lie over to tomorrow. Is there a discussion of the gentleman's motion? Jump from 28, Doug O'Neill.
Thank you, Mr. Speaker. It's obvious that this bill has been thoroughly discussed, thoroughly vetted in committee, and the process needs to work. We've had hours of debate in committee. Our esteemed Education Committee Chairman has done a remarkable job of explaining this. Every member here has heard every single issue. Our distinguished colleagues on the other side of the aisle have made their arguments, good arguments for those who would disagree and want to vote against the bill. I personally believe that every single aspect of this bill has been laid out on the table, and I would just disagree with my colleague's request to lay the bill over and recommend that we vote no on his motion to lay this bill over.
John from the 63rd, Doug Folk.
I wish to speak to the bill, not the motion.
Okay, are there further members desiring to speak to the motion? If not, the question before the House is the gentleman from the 35th motion that the bill lie over till tomorrow. Roll call has been demanded. Is demand sustained? Demand is sustained. All those in favor of the gentleman's motion will vote aye. Those opposed will vote no. The clerk will prepare the machine. The gentleman may close. Gentleman wish to close? Didn't have your light on, so if the gentleman wishes to close, you may close before.
Thank you, Mr. Speaker. Just very briefly, like I said this morning before session, tons of emails. I am only asking for one day so that I can talk to the people at these institutions. One day. We have two bills on third reading. That's it. One day is all I'm asking. Now, I can understand if I was saying postpone it indefinitely, but I am not doing that. I'm asking for one day because, as you heard the gentleman's comments, People in committee vetted this bill. We are on the floor here today. Not in the committee, we are on the floor. Some of us are not on Education Committee. And while I read these bills, we get new information all the time. And before session started today, new information that is contradictory to what I heard on the floor yesterday. So I'm asking for 1 day. That is it. I don't think that's much trouble. Thank you.
Gentleman's closed. For what purpose is the gentleman from the 20? Gentleman must state his point.
Thank you, Mr. Speaker. The motion that's before us is to lay the bill over, and I just want to be clear for our members. If we wish to continue and to vote on this bill today, we should vote no on the motion that's before us. Is that correct?
Gentleman's correct.
Thank you.
Okay.
At issue here is House Bill 2542.
All right. Question before the House is the motion by the gentleman from the 35th to bill over for 1 day. All those in favor of the gentleman's motion will vote aye. Those opposed will vote no. The clerk will prepare the machine.
House Bill 2542 relating to public higher education personnel.
Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, 37 ayes, 62 nays, 1 member absent not voting. Less than the majority of members present having voted in the affirmative, I declare the motion rejected. Are there further members desiring to speak to the passage of the bill? John from 63rd, Delegate Folk.
Thank you, Mr. Speaker. I got a whole different perspective on how I'm voting today and why I'm voting the way I'm voting. And that is, I don't believe in central planning. I don't believe in an organization that shouldn't even exist because it's advisory by what the legislative auditor said last year. I believe that amendments were not allowed that should have been allowed. I believe that we shouldn't continue to allow what I would refer to as a higher education czar to be paid almost $300,000 in his position, while we have tons of people in southern West Virginia out of work. I do believe that we need to allow the institutions greater flexibility. But as you clearly heard, we're replacing one regulatory scheme with another one. The gentleman, the esteemed chair of education, took a large amount of time giving pretty much a dissertation on what this bill does. I offered an amendment to do what the right thing. Actually 2 amendments, one to get rid of the salary, and it was ruled not germane in education, and offered another amendment yesterday to abolish this entity. It shouldn't exist. It's been around since 2000. Most of the people that are probably over 40 years old that went to college in West Virginia, when you went to that institution, this entity did not exist. Was your education any worse because of that? So I'll be voting no.
Other members desiring to speak to the passage of the bill before I recognize the gentleman from the 66 to close. Gentleman from 66, close debate.
Thank you, Mr. Speaker. I'd like to begin by just clarifying one statement I made. Just want to be very clear. In my presentation indicated that the higher education classified employee salary schedule and outdated associated requirements would be eliminated. I wanted to make very clear for members, each of the institutions have already complied with that outdated schedule. This legislation deletes that portion of code. It's simply deleting outdated code because of the fact that all institutions have already met that particular requirement. I heard quite a bit of discussion a bit yesterday and today about the whole aspect of this legislation with regard to bumping and recall. And some of you may recall that I pointed out that West Virginia truly is an outlier in the way that we allow our higher education institutions to staff their facilities. Talked about how if you look at WVU's peer institutions, the 7 public institutions in the Big 12, none of them limit consideration to seniority when making hiring decisions. None of them. So clearly, West Virginia is an outlier. And again, I believe I talked a little bit about how, there's basic unfairness in that scenario where you're going to allow or require, currently we require decision-making regarding classified staff solely on the basis of seniority. So if you have an individual that's even, a year junior to a more senior employee that has stellar performance evaluations, whereas a more senior employee, even slightly senior, may have mediocre documented performance evaluations. No consideration could be given that. Strictly on the basis of seniority. And again, an outlier to peer institutions around the state, around the country. Consider recall rights. Well, if you would agree that allowing bumping solely on the basis of seniority with no consideration allowed for documented work performance, no consideration allowed for the skill sets that an institution requires in order to effectively serve their students. Recall is essentially the reverse of bumping. You have individuals that have separated from an institution, and under current law, those individuals, even though they may not be the most qualified for a particular role that opens up an institution, or may not have the skill sets needed in order to fill a role at the institution, under recall, again, seniority is the sole determining factor. If an individual meets the minimum requirements of the position, you go by the seniority, on that recall list, with no consideration to what the current needs are of that institution with regard to skill sets, and again, with no consideration allowed for, what was the documented work performance of those individuals on that recall list. Now, we heard testimony in House Education. Certainly, institutions, value experience, and quite often, if not most often, those individuals who have the most experience, the most seniority, the most longevity, typically those folks are the most qualified for a particular role. This legislation simply allows for consideration of factors beyond seniority. It doesn't exclude consideration of seniority, but it simply allows to look at documented work performance, skill sets, and other appropriate factors as determined by the Board of Governors at the institution. Also been some references to or suggestions that this legislation is going to open the doors to discrimination. And again, I would reiterate what I said earlier. This bill does absolutely nothing to impact any of the protections that are currently afforded to employees by various laws. And again, just briefly want to review those. Title VII of the Civil Rights Act still remains in effect. The Age Discrimination in Employment Act, again, I think there's been references or suggestions that somehow this is going to lead to age discrimination. That absolutely remains in full force and effect. Title I of the Americans with Disabilities Act, still a protection afforded to West Virginia workers, as well as the West Virginia Human Rights Act. So, Mr. Speaker, I would suggest that any suggestions that somehow this is going to open the door to discrimination ignores the fact that all of those protections that I just referenced remain in full effect. Mr. Speaker, clearly, if we're going to ask our higher education institutions to operate as efficiently and as effectively as possible, we have to provide them the flexibility in order to make the wisest decisions with regard to the use of taxpayer dollars as they can. And again, empower our local, our higher education institutions through their Board of Governors to make decisions that allow them to respond to unique needs at each of our institutions around the state in serving our students. Mr. Speaker, I'd urge passage.
Question before the House is the passage of the bill. Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 61 ayes, 38 nays, one member absent, not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 2542.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Further bills on third reading.
Committee substitute for House Bill 2585, creating felony crime of conducting financial transactions involving proceeds of criminal activity.
Request for the House is the passage of the bill. The gentleman from the 27th delegate shot to explain the bill.
Thank you, Mr. Speaker. And to the members, I mentioned earlier that we were filling in some gaps with some of the bills that will be introduced on the floor. This is one of those. Law enforcement indicated to us last year that the current laws are inadequate as it relates to drug enterprises and drug trafficking, and therefore a bill to establish the offense of money laundering was put together as a result of a joint interim study last year. The version was introduced and passed the House, but was slightly amended by the Senate and did not make it back on messages prior to the close of the session. So we're trying again. And basically what this law is intended to do is to disrupt and prosecute the drug kingpins and enterprises that use local street dealers to wire or transport money back and forth out of state. In particular, it establishes two types of money laundering crimes. First, would make it a felony to wire money or conduct a financial transaction involving the proceeds of criminal activity. Secondly, the second crime created would make it a felony to transport, transmit, or transfer the proceeds of criminal activity. The penalties for both of these offenses are dependent on the amount of money involved. If the amount is less than $15,000, the penalty would be imprisonment of not less than 1 or more than 5 years, and or a fine of $5,000. If the amount is greater than $15,000, the penalty would be imprisonment of not less than 3 no more than 15 years, and or a fine of not less than $5,000 no more than $25,000. The significant difference between this year's version and last year's version relates to the definition of criminal activity. Last year's House version made it applicable to all felonies in the state. The Senate instead opted for a laundry list of felonies in defining criminal activity. This year's committee substitute utilizes the Senate version of the definition and spells out the applicable crimes included under this bill. And for reference purposes, the bill abstract in your system identifies each of the offenses listed in the bill. With respect to other aspects of the bill, the committee substitute makes clear that an individual may be charged in West Virginia if any element of the crime occurs in West Virginia. The bill also states that each transaction, each transfer, transportation, or transmission may be deemed a separate offense. Overall, the intent of the bill is to disrupt the back and forth flow of drug money and to allow for the prosecution of individuals engaged in a criminal drug enterprise. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? Gentleman from the first, Delegate McGee.
Thank you, Mr. Speaker. Will the chair yield for a question?
Gentleman yield. Gentleman yields.
Yes.
Thank you, Delegate. Under the committee substitute, I'm on page 4 here, under the section labeled forfeiture. That's section 61-14-4.
Yes.
I notice in the first line, that's line A as an alpha, I notice the phrase, and upon conviction thereof, is missing after the first phrase of the sentence. So obviously that phrase, and upon conviction thereof, was in the paragraph above the section I'm referring to. I'm not familiar with the West Virginia Contraband Forfeiture Act, but my question would be, can an individual be coerced to forfeit their private property without first being convicted of a crime under that language?
I think the word coerced is the key there. No, there would be a civil proceeding, so they'd have the opportunity to appear. And let me just say that this particular bill does not make any changes to the current forfeiture law other than it establishes a higher burden of proof than is currently required under the forfeiture law. This bill requires clear and convincing evidence as opposed to preponderance of the evidence. Yes.
Yeah, I noticed the clear and convincing evidence part, which is above preponderance. But still, my question is, can a person be required to forfeit their private property without being convicted of a crime, which, if that's the case, would violate the spirit, at least, of the Sixth Amendment and turn the presumption of innocence, a great American principle, upside down?
The only way I can answer that is the forfeiture is a civil proceeding, and there's no criminal conviction required. So it could be, yes, the answer could be yes, that as a result of the civil proceeding where due process is applied, the property could be forfeited even though there's no accompanying criminal conviction.
So, another question. Does the individual have to be charged with a crime before his private property is forfeited? So we've already established that you don't even have to be convicted of a crime before the almighty state could just take their property. Do they have to be charged?
Let me just put it this way, and I haven't participated in any of these proceedings, so I'm giving you what I understand the case is. It typically accompanies an arrest, but it is a separate proceeding. So,
well, you can be arrested just on probable cause, but that doesn't mean you're actually charged with a crime.
Well, typically the arrest leads to a charge, yes.
Well,
I think
typically,
your question was whether that needs a conviction, and the answer is no. It doesn't require a
So potentially no charges even, and definitely not a conviction, and an individual could just have their property taken from them through this civil asset forfeiture process.
It requires an arrest, but yes, it does not require a conviction or a charge. And as I said before, this bill, whether it passes or not, doesn't change the current forfeiture law. If anything, it does strengthen the current forfeiture law by requiring a higher burden of proof.
But that wasn't my question I was getting at.
I understand.
Okay.
I understand.
Thank you. Speak to the bill, please.
John, may proceed.
Mr. Speaker, I rise in opposition to this bill. A hallmark of the American criminal justice system is not only the classic Western principle of proportionality, but innocent until proven guilty. We should not be so careless with passing some of these bills out that violate the presumption of innocence. Because most of the time, these laws that we pass, they're not going to affect the guys that are wealthy and are connected and have access to legal departments. They're going to affect the people that can't afford a good attorney, that can't afford to go through this civil litigation to get back $400 or $500 in cash or $300 in Christmas gift cards because it's too expensive to them. So that's what happens in these cases. It's the poorest in our society that are taken advantage of by unnecessary, unjust laws that violate several deeply American principles. So I ask for once from this body to stand up for what is right and morally just and reject this bill. Thank you.
Further members desiring to speak to the passage of the bill before I recognize the gentleman from 27th to close debate. Gentleman from the 60th, Delegate Wilson.
Thank you, Mr. Speaker. I realize what a long shot this is, but I'd like to ask for unanimous consent to insert upon conviction into the section noted by the gentleman from the 1st District.
You're asking unanimous consent to amend on third?
Yes, sir.
The gentleman's.
Thank you.
The gentleman asked unanimous consent to amend on third. Is there objection? The objection's been heard.
Thank you, Mr. Chairman.
Gentleman from the 55th, Delegate Spinoga.
Will the chairman yield for a question?
Gentleman yields.
Yes.
I noticed you were speaking earlier, there's going to be a lot of bills coming through here. And I anticipate this having a lot of unintended consequences for allowing law enforcement to stack various charges on defendants. My question is, did you guys go out and get a 95B note on what it's going to do to our Department of Corrections budget, public defender's budget, et cetera, on this particular piece of legislation?
No, we did not ask for a fiscal note because in the past, every fiscal note reads the same. It tells us how much it costs to incarcerate a single person and that they cannot predict how many, if any, would be convicted. Of course, part of what we're trying to do here is to send a message that we are going to not tolerate this kind of activity any longer. So it could be that if the message is heard, there might not be a single person that's convicted under this. That's a possibility. But to answer your question, no, that wasn't requested.
Okay, thank you. Commissioner, speak to the bill a second.
Gentleman may proceed.
I'm going to vote no. We have tons, absolutely tons, of criminal bills coming through here. We have $500 million in financial troubles in this state. $500 million. And all we want to do is keep rolling out bills, keep driving up that DOC bill, keep driving up public offenders bills. How many colleges are we going to shut down to pay for that? It's one thing after another in here. All you got to do is look down through the agenda, and this is just the First Amendment. The First Amendment. When thefts occur, and that's what happens, people that are addicted on drugs go out, steal property, transfer it, liquidate it so they got money to buy pills. We know that. And when you see that type of activity increase in a particular area, you know that you have drug problems. But stacking 1, 2, 3, 4, 5, 6, 7 more years on people to lock them up. We've been fighting this war on drugs since the 80s. And if this was a deterrent, on these crimes it was a deterrent, we wouldn't have any crime in the state of West Virginia. We wouldn't have any drug problems. But we're going to keep locking them up, keep costing the state millions of dollars. We need to get smart and quit being so stupid on everything that comes through here. Up in Finance Committee, we had I'll give you an example. What I'm talking about here this last couple years ago. We had the Supreme Court present their budget. We can't do anything about that budget. They set that. We passed something, we set forth 37 new probation officers that were going to just focus solely on sexual offenders in the state of West Virginia.
The gentleman would please keep his remarks to the bill.
That's costing the state $3.1 million. $3.1 million. We didn't get a note then. We don't get a note on anything. We just pass stuff out. And then we come in here and we have $500 million in a budget that and just keep driving the cost up. Enough's enough. I urge you to vote no.
Gentleman from 63rd, Delegate Folk.
Thank you, Mr. Speaker. I'm going to follow up on the questioning from the gentleman from the first with a story. There's a farm over by Middletown, Maryland. I have some cousins that run a dairy farm over there. And the section that he's referring to doesn't require a conviction of any sort. And actually, it's new language because it's underlined. So to say it already exists doesn't matter. You're adding it, so it's in this code. Through civil asset forfeiture, you presume guilty. Guilty. My cousins that run a dairy farm also process their milk and take various products to farmers markets. And they literally were taking thousands of dollars of cash every week to the bank. Sometimes over $10,000, sometimes under $10,000. And their banker actually told them, hey, make sure you structure these properly so you don't raise any red flags. $80,000 is what the government came after and took from them. $80,000. So you don't think that innocent people can get caught up in, if you're not familiar, farmers work on a pretty tight margin. They don't have a lot of money to hire high-dollar lawyers. It's actually made nationwide, Fox News, and it took some farm interest groups getting involved to get their money back. But as the gentleman from the first said, the poor guy driving down Interstate 81 as an example, going from Virginia to Pennsylvania, just happens to be going through with $1,000. Under this, they could take his money on the side of the road and say, come and talk to us in the civil court, and we'll try to help you out. But we have lawyers on staff. It doesn't cost us anything, but it might cost you a couple grand to go hire one in Berkeley County. I'm going to vote no on the bill.
Further members desiring to speak before I recognize the gentleman from the 27th to close debate. Gentleman from the 27th, close debate.
Thank you, Mr. Speaker. As part of our due diligence in the Judiciary Committee and in an effort to address the drug plague that's so devastating to the state, we scheduled an interim meeting and we brought law enforcement in and we asked them, what do we need to do to help you do your job to protect us? This was one area in which they asked us for help. And this bill was a direct result of that request for help. They've indicated to us that they have no tools to address out-of-state activity that results in the provision of drugs in this area. So this bill is an effort to address that. If you don't think law enforcement deserves help, vote no on this bill. If you think that law enforcement deserves our assistance in fighting this plague, then vote yes. Now, this is not a forfeiture bill. Whether this bill is approved or not, the laws affecting forfeiture will be no different, except this bill does strengthen, in other words, make it more difficult, the evidentiary burden in a civil case to seize property. If you don't like the forfeiture laws, we welcome bills to address the forfeiture laws. In fact, I know there's some in the system now and one in the Senate, so we'll have an opportunity to look at those laws. But this bill does not change the forfeiture law in any way, whether you reject it or approve it. This is a bill we need as part of the various tools that our law enforcement have asked for, and it deserves your support.
The question before the House is the passage of the bill. All those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Gentleman from the If so, the clerk will close the machine and ascertain the result. On that question, 78 ayes, 21 nays, one member absent, not voting. The majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 2585.
Are there amendments to the title? Not the title as read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Bills on second reading.
Committee substitute for House Bill 2420, providing that the State Board of Education may delegate its Medicaid provider status and subsequent reimbursements to regional educational service agencies or county boards.
Are there amendments?
Delegates Wilson and Falk move to amend the bills. This is HFA Wilson and Falk 2-28, number 1.
Gentleman from the 60th Gentleman from the 60th asked Nancy to explain the amendment in lieu of having it read. Is there objection? Chair hears none. Gentleman from the 60th.
Thank you, Mr. Speaker. My request here is to correct the oversight in the original bill. I think it's necessary to recognize the inherent roles, rights, and responsibility of parents. Thank you, Mr. Chairman. Mr. Speaker.
Gentleman from the 12th, Delegate Westphal.
Thank you, Mr. Speaker. All due respect, the delegate from the 60th and 63rd, I stand asked to reject this amendment. Purpose of this bill is to allow the county boards to pick and choose the Medicaid, the ones they can bill, they're profitable on. Some of the ones they're billing right now, they're not. They have to bill on all of them. All the students through the Medicaid have an IEP. That's an individual educational plan. The parents are involved with these plans. They know what's going on. The Medicaid dollars are shrinking. If we're trying to help these students, if a parent, for some reason, and the educators in the room know, a lot of times these forms don't come back. They just are thrown in a trash can. This will stop us from getting dollars we're trying to get and desperately get for our local boards. So again, all due respect, I do not think it's needed. I think we will reject the amendment. Thank you, Mr. Speaker.
John from 63rd, Delegate Folk.
Parental rights. You know, when my dad was laid off from Mack Truck back in the 70s and 80s, and I think even in the early 90s once, he never took, we were eligible for food stamps. We never took them. That's his right to say no. So what this amendment does is it says you have to get the consent of the parent before you ask for the public assistance. Is there something wrong with that? Some people are proud people. Some people don't want the money used by the government. This amendment simply says you have to get the consent of the parent. And with all due respect, most parents are going to sign that document if their child needs help. But this amendment simply says you have to get the consent first. I don't think anybody in this room would argue at that point. And I urge passage of the amendment.
Are there further members desiring to speak to the adoption of the amendment? The gentleman from the 60th wish to close debate on the amendment?
No, thank you, Mr. Speaker.
Roll call has been demanded. Is demand sustained? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Demand is sustained. All those in favor of the gentleman's amendment will vote aye. Those opposed will vote no. The clerk will prepare the machine. So each member voted. If so, each member voted. If so, the clerk will close the machine and ascertain the result. On that question, 26 ayes, 68 nays, 6 members absent, not voting. Less than the majority of the members present having voted in the affirmative vote declare the amendment rejected. Are there further amendments? If not, the bill be engrossed and advanced to third reading. Further bills on second reading.
Committee substitute for House Bill 2506 relating to the permit limit calculations and allowing overlapping mixing zones for calculating permit limits for drinking water criteria.
Are there amendments?
Delegate Pushkin moves to amend the bill. This is HFA Pushkin 2-28.
Gentleman from the 37th asks unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none. Gentleman from 37.
Thank you, Mr. Speaker. This is a fairly simple amendment, and what it would do is provide for the Secretary to require that the permit holder, one who's allowed the permit for one of these overlapping mixing zones, they'd be required to post signage on the shore stating that a warning, pollution mixing zone, stream pollution in this area exceeds state water quality standards, swim at your own risk. It's fairly simple. I believe it does no harm to the intent of the bill. What it does, it's extra protections for our citizens that we're here to represent, and just clearly stating that, yes, the amount of toxins in this part of the river, this part of the stream, are higher than the regular water standards. And it says swim at your own risk. So I would request the right to close.
Are there other members desiring to speak to the adoption of the amendment? Jump from 33rd, Doug Hanshaw.
Thank you, Mr. Speaker. Ladies and gentlemen, I believe the amendment is well-intentioned, and with a little modification, I could perhaps support it. I want to first make sure that the text of the amendment conforms to our existing law. So, for example, there is a signage requirement in place now for holders of NPDES permits. So if you are the holder of such a permit, you do have to have a sign there now, and there are parameters that govern what's on that sign. I wonder if the delegate would be willing to accept the reformation to that effect, specifically a reformation such that we would strike the language after the word secretary and insert that the secretary may require permittees to indicate on their required signage an indication that mixing zones overlap in a particular vicinity.
The gentleman seeking to requesting that the amendment be reformed.
Would accept
I'm asking the gentleman if he would consider the reformation.
If you change that may to a shall.
Shall require permittees to indicate on their required signage an indication that mixing zones overlap in a particular vicinity. If the gentleman would accept that reformation, Mr. Speaker, I could support the amendment.
The gentleman asks unanimous consent that his amendment be reformed in such a manner. Is there objection?
I'll provide that language to the clerk, Mr. Speaker.
Chair hears no objection. The amendment will be reformed as indicated. For the benefit of the members, if the gentleman from the 33rd would just restate exactly what the amendment would now read.
Yes, Mr. Speaker. So the gentleman's amendment as reformed would strike everything after the word secretary and insert the following: shall require permittees to indicate on their required signage an indication that mixing zones overlap in a particular vicinity, such that if adopted, the parameters incumbent upon a permittee would comport with existing signage requirements. So the permittee is already required to have signs posted at the discharge outlet. The gentleman's amendment would dovetail with that existing requirement of law.
If the gentleman would bring that reformation to the clerk's desk, that would be helpful. Are there other members desiring to speak to the amendment as reformed? The lady from the 51st, Doug Fletcher.
Thank you, Mr. Speaker. Really, I had a question for the gentleman from Kanawha. I'm not sure when you were undertaking to reform your amendment, that you were going to leave out the warning side at the end that said swim at your own risk. Is that your intention?
The gentleman yield. Gentleman yields.
No, that's not my intention. Upon reviewing it further, I guess I would have to ask the gentleman from the 33rd to yield again and see if he'd be willing to add that to his suggestion on the amendment.
Gentleman from 33rd.
I misheard, or I didn't hear the question.
What the gentlelady from 51st
Well, my
had asked
question
me.
was when the
Just
my
for this
question was
moment,
for
if we
the,
could, just because we're having 2 or 3 people on a debate here. The gentleman has answered your question. Do you wish for the gentleman from the 33rd to yield? Is that what your request was? The gentleman from 33rd yield?
Sure.
Gentleman yields.
So on your suggested reform to the amendment, it would take out the warning aspect of the sign. Is that correct?
It would. I think that's part of what doesn't comport with existing law. So under the current law, or under the current wording of the amendment, there's a statement that may or may not be factually correct about any exceedances of current water quality standards. That may be correct, or it may not be.
What's that?
If the current signage is in regulation or rule, then this would supersede that. This notice as well.
Okay.
At issue here is House Bill 2506, relating to the permit limit calculations and allowing overlapping mixing zones.
Or in statute?
I think the requirement that the signage be posted is in statute and the content be in rule, but it's been a while since I've looked at that, so I don't recall.
Okay.
My recollection as I stand here is that the signage requirement itself is a statutory parameter, whereas the content of that sign is by rule.
And this would be consistent with the statute. It just gives us specificity, so I think you could clearly add swim at your own.
So I don't think it would be, in conflict with the existing statute if we added a warning to let people know before they swam in that area that they were swimming at their own risk, and that this part of the stream did allow for a higher amount of toxins and pollutants than the state law already allows.
My point is that may or may not be factually correct. So as drafted, the pending amendment presents as a factual statement that is the case, and it may be the case or it may not be the case. I don't think we want to mandate that a permittee post a statement in compliance with law which may not be factually accurate.
Well, if it did exceed it, would they be able to post? Hold on.
Do you agree to change the word that it may exceed? May. Add it here, may exceed. You could agree to that, but don't agree to it.
Okay. I would agree to change it so that what it would say the stream pollution in this area may exceed state water quality standards. Basically, what I'm trying to do is keep the warning on the sign and to make sure that it's factual. Say, warning, the stream pollution in this area may exceed.
And my point is that the issuance of a warning may or may not be called for. That's a factual determination that's unique per permittee. And I'm in sympathy with your amendment that you want to call to the attention of users of the body of water that this is an area in which the Department of Environmental Protection has authorized the overlap of mixing zones. That makes sense to me. I'm willing to accept that and support the gentleman's amendment if you could accept my proposal. I mean, I'll consent to the may to shall, but I don't think I can go any further than that.
Okay. Could you repeat your proposal one more time?
Yes, sir. So striking after the word secretary, the rest of the amendment, and inserting in lieu thereof, shall require permittees to indicate on their required signage an indication that mixing zones overlap in a particular vicinity. That would call to the attention of any user of the body of water what I think the gentleman is trying to raise.
I'm sorry, but I don't think that goes far enough. That's just adding to the existing signs that they have. It really doesn't give warning to a potential swimmer that they're getting ready to get into a part of the river that where in most cases it's going to exceed it's going to exceed the state water quality standards. If it wasn't, there wouldn't be limits on how close it could be to an intake.
If I could just, because I think we're getting a little far afield
So,
here.
no, I don't agree.
You have an amendment pending. There was a request from the gentleman from 33rd if you would be willing to reform that amendment in such a way as he read, and you asked that be reformed, and there was no objection. So if you want to further reform it to say back to where you were, I think you would have to ask unanimous consent to do that. So it's up. I think it's in the gentleman's court here what he wants to do as far as
unanimous consent to reform the reformed version of it.
So we would need to know exactly what you want the amendment to say, so the members would know. If the gentleman from the 33rd and the gentleman from 37th.
I'd be happy to short-circuit the process, Mr. Speaker, if you'd like, and move to amend the pending amendment by striking everything after the word secretary and inserting in lieu thereof the language at the desk.
I believe we've already, by unanimous consent, reformed the amendment to that effect. So what we have in front of us is an amendment that has been reformed in the manner that you had read from the floor. So if the gentleman wishes to reform that, that would be, and I believe that's what you've now asked to do. The gentleman has asked unanimous consent to reform his amendment, and we need to know exactly what he wants that amendment to say. Okay, gentleman for 37.
Just to be clear, we're back to the original amendment that's posted on the automation system, correct?
Okay. If that's what the gentleman is asking to reform his amendment.
That's what I'm asking.
Is there objection? Chair hears none. So the amendment is now back to what the gentleman from the 37th originally placed in the system. Are there amendments to that amendment? Gentleman from the 33rd. Delegate
Speaker, I move to amend the pending amendment by striking everything after the word secretary and inserting in lieu thereof shall require permittees to indicate on their required signage an indication that mixing zones overlap in a particular vicinity.
Is there discussion of the gentleman's amendment to the amendment? If not, the question for the House. The lady from 51st, Delegate Fletcher.
Thank you. I think the amendment to the amendment eviscerates the intent of the gentleman's original amendment, and that was to warn people that swimming could be risky. It takes that out of the amendment, and for that reason, I oppose the amendment to the amendment.
Just for the clarity of the members, what I'm going to ask the clerk to do is to read the amendment that's pending before us from the gentleman from the 37th, Delegate Pushkin, and the proposed amendment to that amendment, so that everyone is clear. So what we will then vote on is the proposed amendment to the amendment by the gentleman from the 33rd. If the gentleman would first read the amendment that the gentleman from the 37th, Delegate Pushkin, has offered, then we can read the amendment to that's been offered.
Delegate Pushkin moves to amend the bill on page 2, section 7B, line 28, following the period, by inserting the following sentence. At locations where mixing zones are allowed to overlap, the Secretary shall require the permittee to post signage on the shoreline in near proximity to the water body mixing zone in lettering at least 1 inch in height, a notice that reads, "Warning, pollution mixing zone, stream pollution in this area exceeds state water quality standards. Swim at your own risk."
Then the gentleman from the 33rd has moved to amend that proposed amendment, and if the clerk would please read that proposed amendment to the amendment.
Delegate Hanshaw moves to amend the amendment by striking everything after the word secretary and inserting in lieu thereof the following: shall require permittees to indicate on their required signage an indication that mixing zones overlap in vicinity in a particular vicinity.
Now, the question now pending before the House is the motion by the gentleman from the 33rd, Delegate Hanshaw, that the gentleman from 37th's amendment be amended as read. Is there discussion as to the amendment to the amendment by the gentleman from the 33rd? Gentleman from the 37th, Delegate Pushkin.
Thank you. I stand in opposition to the amendment to the amendment. I'm thinking from a practical standpoint, it really does not go far enough to alert the public as to possible dangers. They're already required to have certain signage there if they are exceeding the acceptable levels by state code. So adding to these signs really doesn't get the message out that swim at your own risk. Simply, to state it bluntly, it really takes the teeth out of the amendment. It would only be changing signs that were already required. However, what we're doing now is creating a new zone in the river where we're allowing these entities to put the discharges closer together, creating what we didn't have before, overlapping mixing zones. That's something new that we're now allowing in this statute, in this bill. So, pointing that out, making it more clear to the public that this is probably not a place you want to swim. I think that would go a long way in protecting the people that we're here to serve. So I stand in opposition to the amendment
Jump from 32nd, Delegate Pass.
Thank you, Mr. Chairman. Would the Vice Chairman of Judiciary yield?
Gentleman yields.
Delegate, there is a concern that you have with the gentleman's primary amendment that you seek to amend, that on any given day or any given point in time, the pollution standards may not, as it says, violate or exceed state water quality standards. Sometimes it may, sometimes it may not. Therefore, the way the gentleman's amendment is written, it may not be factually correct at a certain point in time. Is that a concern of the gentleman?
Yes.
Thank you.
Lane from the 35th, Delegate Lane.
Will the gentleman from the Vice Chairman yield to a question?
Gentleman yields.
Does your amendment make this a better bill, or is the bill, or should we just be voting no on your amendment and no on the original amendment?
Well, that is your decision, not mine. I simply said when I rose initially that I thought the gentleman's amendment was coming from a place that was defensible, that if we want to provide additional notice to the public that the Department of Environmental Protection has made the sound decision that this is a place where overlapping mixing zones are allowed, that we could say so in a way that comported with existing law. And my amendment seeks to do that. Whether it's better or not is your decision.
Well, now I have another question. Are you going to vote for your amendment?
I am.
Okay, thank you.
Are there further members desiring to speak to the amendment offered by the gentleman from the 33rd? Does the gentleman from the 33rd wish to close debate on it? Question before the House is the adoption of the amendment to the amendment. All those in favor will say, I believe a roll call was demanded on was that to the amendment to the amendment? Okay, roll call as to the amendment to the amendment was demanded. Is demand sustained? Demand is sustained. All those in favor of the amendment to the amendment will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 58 ayes, 35 nays, 7 members absent, not voting. The majority of members present having voted in the affirmative, I declare the amendment to the amendment adopted. Question now before the House is the adoption of the amendment as amended. Or is there a discussion? Does the gentleman from the 37th wish to close debate on the amendment?
I stand in support of the gentleman's amendment, and I appreciate the help in how we might have thought we were helping and make it conform with already existing rules. However, I do think it really took the teeth out of it, but still, I think it's a good amendment, and it might help alert the public to where they should or shouldn't be enjoying our beautiful state waterways. But I do support the amendment. Thank you.
Question before the House is the adoption of the amendment. All those in favor will say aye. Aye. Those opposed, no. The ayes appear to have it. The ayes do have it to declare the amendment adopted. Are there further amendments? If not, the bill will be engrossed and advanced to third reading. Bills on first reading.
Committee substitute for House Bill 2329, prohibiting the production, manufacture, or possession of fentanyl.
Bill be advanced.
Committee substitute for House Bill 2620, West Virginia Drug Overdose Monitoring Act.
Bill be advanced.
Committee substitute for House Bill 2646, terminating the Women's Commission and discontinue its functions.
Bill be advanced.
Committee substitute for House Bill 2648, increasing penalties for manufacturing or transportation of a controlled substance in the presence of a minor.
Bill be advanced. Leaves of absence. Remarks by members of the House. The gentleman from 26, Doggett Evans.
Thank you, Mr. Speaker. Last night about 10:30 p.m., a McDowell County minor lost his life in the performance of his job. It's being reviewed, of course, by company officials and the Office of Mine Health and Safety. I'm sure they'll make recommendations to prevent this from happening in the future. My heart goes out to the family, the co-workers, and the friends of the miners. Our mining community is a family. As such, we all grieve together. No one wants to get that call that they've lost a loved one or a family member. Let's all work together to increase and keep in place laws and regulations that prevent and protect all our workers. Mr. Speaker, I ask unanimous consent for a moment of silence honoring the miner and all those that died in the dark.
If all members and guests would please rise for a moment of silence. Members may be seated. Further remarks by members. John for the 50th, Dr. Caputo.
Thank you, Mr. Speaker. I just want to ask unanimous consent that the remarks by gentleman 26 on the fallen miner be placed in the appendix of the journal.
Without objection, remarks be placed in the appendix of the journal. Miscellaneous business. Gentleman from the 28th.
Thank you, Mr. Speaker. Subject to announcements, I move the House adjourn until 11 a.m. tomorrow.
Are there announcements? Gentleman from the 64th, Delegate Householder.
Thank you, Mr. Speaker. The Committee on Finance will meet tomorrow, March 1st at 9 a.m. to consider legislation. The agenda will be posted. The committee will continue with its budget hearing at 9:30 with the Bureau of Senior Services. At 2 o'clock, we will meet with the auditor's office, and at 3 o'clock for the Department of Agriculture's budget presentation. Following the presentation, we will be considering legislation, and the agenda will be posted.
John from the 33rd, Doggett Hanshaw.
Mr. Speaker, the Committee on Judiciary will meet tomorrow morning at 9 a.m. The agenda is already posted.
John from the 51st, Doggett Statler.
Mr. Speaker, your Committee on Education will meet tomorrow at 2:30 p.m. in the Educational Committee room. The agenda will be posted.
John from 66, Doggett Espinosa.
Thank you, Mr. Speaker. For members who will be observing Ash Wednesday tomorrow, wanted you to be aware that there will be an Episcopalian priest who will be dispensing ashes from 10 to 11 a.m. in room 215E. Again, that's from 10 to 11 a.m. tomorrow morning in room 215E. Thank you.
Lane from 31st, Doggett Arbonne.
Thank you, Mr. Speaker. Your Committee on Government Organization will meet tomorrow afternoon, Wednesday, March 1st at 3 p.m. in the Government Organization Committee Room, 215 East. The agenda will be posted.
John from the 27th, Doggett Ellison.
Thank you, Mr. Speaker. Your Committee on Health will meet at 3 o'clock today. The Republicans will caucus in the chairman's office at 2:30. Thank you, Mr.
Lane from the 32nd, Doggett Kessinger.
Thank you, Mr. Speaker. Your Republican members on the Committee of Prevention and Treatment of Substance Abuse will meet in the chairman's office immediately following adjournment, and the entire committee will convene at 4:30 this afternoon in the Government Organization Committee room. The agenda is posted. Thank you.
Lady from the 59th, Doggett Blair.
Thank you, Mr. Speaker. Your Committee on Political Subdivisions will meet today at 2 p.m. in House Education. Thank you.
John from the 48th, Doggett Hamrick.
Thank you, Mr. Speaker. Your Government Organization Committee work groups will meet tomorrow morning at 9 a.m. as follows. Work Group A, led by Delegate McGeehan, will meet in the committee room 215E. Work Group B, led by Delegate Hill, will meet in room 228E. Work Group C, led by Chairman Howe, will meet in the Chairman's office 213E. Work Group D, led by Vice Chair Arvon, will meet in the committee room 215E. And Work Group E, led by myself, will meet in my office 206E. On the agenda will be the discussion of legislative audits that have recommended cost savings to the state.
John from the 47th, Doggett Wagner.
Thank you, Mr. Speaker. Your Committee on Veterans Affairs and Homeland Security will meet tomorrow, Wednesday, March 1, at 1 o'clock in the House Education Committee room. The agenda is posted.
John from 63rd, Doggett Fowl.
Thank you, Mr. Speaker. The Committee on Pensions and Retirements, just a reminder, we're meeting this afternoon at 4 o'clock in the Finance Committee room, and the agenda should be posted.
John from 32nd, Doggett Fast.
Thank you, Mr. Speaker. We'd like to start a prayer caucus, and the prayer caucus will meet back in the main entrance 5 minutes before session, have a short prayer for God's blessing and wisdom upon our session, starting tomorrow. Thank you.
John from 63rd, Doggett Fowl.
Thank you, Mr. Speaker. I forgot one thing. The gentleman from the first asked me to ask for unanimous consent that his remarks on House Bill 2585 be printed in the appendix of the journal.
Without objection, remarks be printed in the appendix of the journal. John from 35th, Doggett Nelson.
Yes, thank you, Mr. Speaker. I'd like to inquire as to the availability of the House chamber for Monday, the 13th at 9 a.m.
Chamber is available.
Thank you. I'd like to announce that the Joint Standing Committee on Finance will hold a joint informational meeting Monday the 13th at 9 a.m. here in the chamber. The purpose of this meeting is to hear from the Commerce Secretary, Thrasher, on the Save Our State, as well as an independent party will discuss West Virginia's competitiveness in the local business market. All members will be welcome to attend. Thank you.
John from 28th, Doggett O'Neill.
Thank you, Mr. Speaker. For the Republican members, the caucus scheduled for today after session has been postponed to a day later in the week to be announced.
Lady from the 50th, Doggett Longstreth.
Thank you, Mr. Speaker. The Democrat members of the Health Committee will have a caucus today at 2:30 in room 151. Thank you.
Further announcements? If not, the question before the House is the motion by the gentleman from the 28th to House stand adjourned until 11 a.m. tomorrow. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. Declare the House adjourned until 11 a.m. tomorrow.
You've been watching the House of Delegates live from the Delegates Chamber at the State Capitol in Charleston. We have recorded today's Senate floor session, and we'll bring that to you shortly. House Bill 2506, the subject of much debate during the floor amendment stage, relating to the permit limit calculations and allowing overlapping mixing zones for calculating permit limits for drinking water criteria, will be up for debate and passage tomorrow. And now we'll take a look at what the Senate was doing while the House was in session.
Senate will please come to order. Senate will please come to order. All those not having privileges of the floor will please vacate the chamber. Would those on the floor and our guests in the gallery please rise as we are led in prayer this morning by the Reverend Jeff Biddle of Emmanuel Baptist Church in Charleston, West Virginia, and then please remain standing as we are led in the pledge today by the senior senator from the 17th.
Let us pray. Dear Heavenly Father, thank you for this day, and thank you for the beautiful state of West Virginia that we are blessed to call home. We pray that you would pour out your blessings on the home that we love, that you would fill this place up with love and joy, hope and courage. Teach us every day how to love one another, support one another, how to choose what is right, and how to care for all that you have given us. For you have not given us a spirit of timidity, but of power, love, and self-discipline. We thank you for the men and women in this room. Please give them strength and wisdom to lead, govern, and guide this state with love and insight. Inspire them each day with the hope of a bright future and the tenacity to help bring that future into being. Lord, we thank you for your love, and we trust your provision. In Jesus' name we pray. Amen.
Thank you, Reverend. The senior senator from the 17th.
Thank you, Mr. President. Will everyone in the gallery please join us as we honor the flag by saying the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Reading of the journal.
West Virginia Legislature Senate Journal, Monday, February 27th, 2017. The Senate met at 11 a.m.
The senior senator from the 4th requests unanimous consent that further reading of the journal be dispensed with and that it be approved as having been read. Is there objection? Chair hears none. So ordered. Introduction of guests. On behalf of the Senate, it is my pleasure to welcome our honorary pages for the day. Please stand and be recognized as your name is called. As guest of the senior senator from the 6th, we have Andrew Rife, Lillian Wright, and Renee Crenshaw. As guest of the senator from Preston, we have Molly Meza. As guest of the senior senator from the 8th, we have Van Lucas and Todd Jared. As guest of the junior senator from the 8th, we have Tanner Samples. And as my guest, we have Andrew Francis, Hayden Hunter, Christian Deese, and Brett Parsons. Would they all please stand and the Senate make them welcome? Further introductions. The senator from Ohio.
Thank you, Mr. President. It's my pleasure and yours to introduce our doc for the day, Dr. Kimberly Becker of Clendenin, West Virginia. If she would stand, and the Senate please make her welcome.
Further introductions, the senator from Ohio.
Thank you, Mr. President. Also on your behalf and behalf of the finance chairman, we have the parents of some of our pages today. Andrew Francis's mother, Cinda Francis, is here in the president's gallery. We also have Hayden's dad, Tom Hunter, and Joe Stevens, who is Christian's dad. If they would all stand, and the Senate please make them welcome.
Further introductions. The senator from Preston.
Thank you, Mr. President. And on behalf of the senator from Tucker and myself, we're pleased to have in the North Gallery Laura Mazza, who is the chaperone of Molly, who is paging for us today. Laura, if you would please stand up, and the Senate, please make her welcome. And Mr. President, I would also like to recognize Dr. Bill Shockey, who is the Preston County Extension Agent from WVU, seated in North Gallery also. Bill, if you'll stand up, and the Senate, please make him welcome. Thank you for being here today.
Further introductions, the senator from Marion.
Mr. President, on behalf of the senior senator from Monongalia, we have a friend of ours down from Fairmont, Gary Wick, who is in the South Gallery. He's with the AARP. If the Senate would make him welcome.
Further introductions, the senator from Cabell.
Thank you, Mr. President. On behalf of my senior senator from the 5th, seated in the South Gallery with the AARP group are Irvin Scarberry and Mary Gill. Would you please stand and be welcome?
The senator from Wood.
Thank you, Mr. President. In the South Gallery, we have the good folks of West Virginians for Health Freedom, and they are a statewide organization, and they're down here today to generate support for their bill for SB 359, providing religious and conscience exemptions for compulsory vaccinations in West Virginia. If you good folks would stand, and would the Senate please make them all welcome.
Further introductions, the junior senator from the 17th.
Thank you, Mr. President. In the gallery today, we have Jessica Meadows, who was one of our interns last year, but she's here today representing the Governor's School Advisory Council. If they wouldn't mind standing, and the Senate make them welcome.
Further introductions, the senator from Tucker.
Thank you, Mr. President. On behalf of the senator from Preston and myself, we have a good friend and constituent from Taylor County with us today in the North Gallery. If John Taylor, who's also a volunteer of AARP, if he'd stand, and the members make him welcome.
The senior senator from the 8th.
Thank you, Mr. President. On behalf of the junior senator from the 8th, I would like to welcome today the mother of our page, Todd Jarrett, Paula Jarrett, the grandmother, our own Mary Jane Dexter, and Paul is also the aunt of Van Lucas, who's one of our honorary pages. If they would stand, the Senate, please make them welcome. Him right up here. Also, Mr. President, we have two good AARP volunteers here. Margaret and Bob Price are here. I'd like for them to stand and have the Senate make them welcome, please.
The junior senator from the 8th.
Thank you, Mr. President. On behalf of myself and my senior senator from the 8th, one of our pages here today, Tanner Samples, which is my nephew. Accompanied today is his father, Jeffrey Allen Samples. If he would stand, give him a warm welcome.
The senator from Harrison.
Thank you, Mr. President. On behalf of my senior senator from Braxton, it's my pleasure and yours to introduce today Jerry Lynn Shear, who's sitting in the audience up here. She's a lifetime member in Lewis County and a great service to her community. Please welcome her.
Further introductions, the senator from Ohio.
Thank you, Mr. President. I move that the Senate stand in brief recess for the purpose of hearing a presentation from the Governor's Honors Academy.
The senator from Ohio moves that the Senate stand in brief recess to hear an address by the senator, or our good friends from the Governor's Academy. So all those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the Senate in brief recess. Please welcome, before we acknowledge them, please welcome two representatives from the governor's schools who are going to speak with us today about their experiences in the summer of 2016. Both of these young people were selected by their peers to represent them on the Governor's School Advisory Council. From the Governor's School of the Arts, we have Jacob Martin, a junior at Nicholas County High School. The Governor's Honor Academy representative is Emma Locarnia, who is currently a senior at Washington High School in Jefferson County. Both students are accompanied by their parents and members of the Governor's Schools Advisory Council. Let's give these young people our attention.
Thank you. President Carmichael, esteemed senators, members of the Governor's School Advisory Council, family, and friends. This past summer, I, along with 119 other students, was given the amazing opportunity to attend the Governor's School of the Arts. Little did I know the true effect the school would have on my life and on my musical career as a whole. When I first arrived at GSA, I was greeted with a smile, and then I met some of the kindest, most outgoing individuals that I've ever had the honor of meeting. My main participation was an instrumental musician. After acquaintances were made and everyone was settled, we had lectures in our main discipline groups. My teachers were Mr. Posey and Dr. Moore. I noticed that the skill level of all the students in my discipline varied, in some cases quite drastically. But that didn't matter when it came to Mr. Posey and Dr. Moore. No, we began our 2-hour lesson with Mr. Posey and would end with Dr. Moore. We used a method of improvising. Nothing was on paper, and it was not as strict as I thought it would be. Also, due to the mixture of instruments, some very interesting melodies and songs were created in our small family of instrumental musicians. Then they jammed us into groups and said, "Write a song, good luck, have fun." And we were left to ourselves and would soon perform the piece in front of the rest of the class. I recall the first time I used improv in music. Playing violin, or fiddle, I should say, in West Virginia landed me among some old-timers at a bluegrass jam, and to put it blatantly, it was terrifying. It was obvious that many of my fellow peers had never used improv before. Tension was a common factor in the room, and for the first week, and no one escaped. Everyone had a chance in the spotlight. This threw me off at first. I thought the Governor's School for the Arts would be strict, just down to the bone classical, with no room to breathe. It was exactly the opposite. I would ask myself, why teach improv? Then it dawned on me. They were pushing us out of our comfort zone to help us improve. They weren't just teaching improv or how to read music, but they were brilliantly teaching us confidence and how to work together as a team, how to believe in ourselves. How they did this is beyond me. It seemed that a newfound confidence flooded the campus. People from my own school who wouldn't dare stand in front of 120 people and speak would own the floor like they were a completely new person. The Governor's Schools are an amazing opportunity in West Virginia, and I thank you greatly for making this experience possible for me. Sadly, it is no secret that our state is hurting financially. I truly believe that these schools are worth the investment. This is an area where funding is needed and is being used for the better. These schools change lives. It changed mine. If someone asks you, why would you fund the Governor's Schools? You could look them in the eyes and say simply, they teach confidence. What other school teaches that? As for that confidence, where does it go? It comes here and goes everywhere in West Virginia. I know 120 amazing and confident people who would do an outstanding job at helping this state. Don't let this good opportunity slip through our fingers. Help us keep it open so that we can make West Virginia better, one person at a time. Thank you.
Mr. President, ladies and gentlemen of the Senate, members of the Governor's School Advisory Council, and guests, thank you for allowing my colleagues and me to speak on behalf of the Governor's Schools of West Virginia. Having attended both the Governor's School for the Arts and the Governor's Honors Academy, I can confidently say that these experiences have deeply impacted my life. Not only did they encourage me to increase my academic prowess and help me hone my musical talents, but my time residing at 2 West Virginia colleges is the main reason I plan on attending an in-state university. During the governor's schools, I was given the opportunity to discover the state, learning about its rich history and visiting new places. This travel also opened my eyes to the amazing opportunities and wealth of talent here in West Virginia. Unsurprisingly, I was not the only student to realize this. Students who had erroneously assumed their home state lacked the resources for them to develop a career quickly changed their minds. Traveling to see plays and musical performances proved the arts in West Virginia are alive and well. Touring the state capitol and exploring museums gave students an up-close view of the unique and wonderful culture that West Virginia has developed throughout its history. And working one-on-one with intelligent and caring staff at West Virginia colleges showed that attending college here will give a student a world-class education surrounded by adults who will help students reach their goals. A program that shows off West Virginia's promising potential to the brightest young minds in the state is an invaluable resource. These young students are going to be the driving force of the future, and convincing them to stay in West Virginia will continue to add to the growth and the development of our state. Not only do the governor's schools help keep talent and intelligence in the state, but they help develop students into a well-rounded global perspective. At GHA, students were addressed by speakers from all walks of life, with extremely different and even controversial opinions. But instead of dividing the student body by bringing these ideas to the center of attention, it forced students to challenge their beliefs and even become aware of new issues. Therefore, students with opposing opinions developed a sense of respect for each other as they could understand and relate to both sides of a conflict. This level of maturity and awareness is rare, as is the exemplary citizenship all students demonstrated during the governor's schools. During community service activities, not one complaint was heard from the entire student body, no matter what kind of conditions we were working in. With kind smiles, students helped pick up trash, worked in soup kitchens, and sorted clothes at local community ministries. And when a program aimed at encouraging young West Virginians to vote, Inspire West Virginia, asked for volunteers, many of my peers leapt at the opportunity and are still active in the program today. This unmatched passion for the betterment of our state is only found at the governor's schools, making the continued funding of this wonderful experience to be both an asset to the state of West Virginia and a benefit to all West Virginia students. While we may be facing a monetary deficit, let us not find ourselves in an educational deficit. An actuary might ask, how can we afford to continue these programs in such tough financial times? My answer, and I hope yours, is in these perilous, brain-draining times, we can't afford not to have them. Make my mantra yours, GHA forever. Thank you.
Great messages. Thank you very much. Thank you, Emma and Jacob. The Senate will come to order. The Senate will come to order. Those were amazing addresses. Thank you. Communications from the House.
The Clerk of the House announced the passage by that body of engrossed committee substitute for House Bill 2001 relating to ethics and transparency in government.
Message be received and referred to the Committee on the Judiciary.
Engrossed committee substitute for House Bill 2028 relating to the venue for suits and other actions against the state.
Message be received and referred to the Committee on the Judiciary.
Engrossed committee substitute for House Bill 2359 relating to offenses and penalties for practicing osteopathic medicine without a license.
The message will be received and referred to the Committee on Government Organization and with a second reference to the Committee on the Judiciary.
Engrossed committee substitute for House Bill 2479, Uniform Deployed Parents Custody and Visitation Act.
The message be received and referred to the Committee on the Judiciary. Reports from the Executive. Communication from the Executive.
There are none.
Reports from standing committees.
Your Committee on Natural Resources has had under consideration Senate Bill 28, creating new system for certain contiguous counties to establish regional recreation authorities, and has amended same, and reports the same back with the recommendation that it do pass as amended, but under the original double committee reference, first be referred to the Committee on Government Organization. Respectfully submitted, Mark R. Maynard, Chair.
The report will be received, and under the bill's original double committee reference will be referred to the Committee on Government and Organization. Further reports?
Yes, sir. Your Committee on Government Organization has had under consideration Senate Bill 190, eliminating bidders' preference for in-state vendors on state contracts, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass. Respectfully submitted, Craig Blair, Chair.
The report will be received.
Your Committee on Banking and Insurance has had under consideration Senate Bill 344, relating to application of payments on consumer credit sale and loans, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass, but under the original double committee reference, first be referred to the Committee on the Judiciary. Respectfully submitted, C. Edward Gaunch, Chair.
The report will be received, and under the bill's original double committee reference, we will be referred to the Committee on the Judiciary.
Your Committee on Natural Resources has had under consideration Senate Bill 410, relating to marking traps with DNR identification tag, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass. Respectfully submitted, Mark R. Maynard, Chair.
The report will be received.
Your Committee on the Judiciary has had under consideration Senate Bill 439, relating to venue for civil and criminal actions at Salem Correctional Center, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass. Respectfully submitted, Charles S. Trump IV, Chair.
The report will be received.
That's all I have.
Reports from select committees.
There are none.
Introduction of bills. Senator from Ohio.
Thank you, Mr. President. I request unanimous consent that Senate Bill number 458 through Senate Bill number 484 be considered and introduced, read by their titles, and referred to the appropriate committees as shown on the chamber automation system.
The senator from Ohio requests unanimous consent that Senate Bill number 458 through Senate Bill number 484 be considered introduced, read by their titles, and referred to the appropriate committees as shown on the chamber automation system. Is there objection? Chair hears none. So ordered. Unfinished business. Resolutions.
Senate Concurrent Resolution 24 by Senators Romano, Facemeyer, and Stallings, naming the U.S. Army Private First Class Joe Messy Sr. Memorial Bridge.
Under the rules of the Senate, the resolution will lie over 1 day.
Senate Resolution 24 by Senators Stallings, Plymel, Takubo, Unger, and Ojeda, congratulating Chapmanville Lady Tigers softball team for winning the 2016 Class AA State Championship.
The senator from Boone.
Thank you, Mr. President. I request unanimous consent that the resolution be taken up for immediate consideration, committee reference be dispensed with, and the resolution be put upon its adoption.
The senator from Boone requests unanimous consent that the resolution be taken up for immediate consideration, committee reference be dispensed with, and the resolution be placed upon its adoption. Is there objection? Chair hears none. So ordered. The clerk will read the resolution.
Senate Resolution 24, congratulating the Chapmanville Lady Tigers softball team for winning the 2016 Class AA State Championship.
The question is on adoption of the resolution. The senator from Boone.
Thank you, Mr. President. It's my pleasure to recommend adoption of this resolution. The Chapmanville Regional Lady Tigers have won the 2016 Class A championship with a 33-6 record. They have been dominant not only in 2016, but they've won state titles in 1999, 2004, 2007, 2009, 2010, and 2016. They are coached by the legendary head coach Ronnie Uten and assistant coaches Barb Uten, Dave Elkins, John Carter, and D.A. Harless. They routinely whip up on my Scott Skyhawks, Lady Skyhawks. But it's always a competitive area that they come from. I am very pleased to say that the Logan County Commission and we up here have tried to provide the best athletic facilities available to them. And they are used not only by the student athletes, by the entire community to better their health. So with that, I am pleased to recommend adoption of this resolution.
Further discussion? The senator from Logan.
Thank you, Mr. President. I too stand in support of this resolution. As a person who actually teaches at Chapmanville Regional High School, I see how hard these young ladies have worked to be able to accomplish this feat. Also, I would like to state that the coach, Ronnie Uten, has been recently named National Coach of the Year. These people absolutely go above and beyond for what they do. The coaches go above and beyond for what they do for these students. And I'm very proud to say that I belong to the organization, the school, that these wonderful people serve at every day. Thank you, Mr. President.
Further discussion. The senior senator from the 6th.
Thank you, Mr. President. They're not technically in my district, but my daughter was a varsity pitcher for the Wayne Pioneers. So I have seen these ladies in action, and they deserve this honor. Thank you.
Further discussion. Further discussion. If not, the question before the Senate is adoption of the resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the resolution adopted. The senator from Ohio.
Thank you, Mr. President. I request unanimous consent that the comments by the senator from Boone, the senator from Logan, and the senior senator from the 6th, as it pertains to Senate Resolution 24, be printed in the appendix of the journal.
The senator from Ohio requests unanimous consent that the comments by the senator from Boone, the senator from Logan, and the senior senator from the 6th be included in the appendix of the journal. Is there objection? Chair hears none. So ordered. The senator from Ohio.
Thank you, Mr. President. I move the Senate stand in brief recess for the purpose of presenting the resolution.
The senator from Ohio moves that the Senate stand in brief recess for the purpose of presenting the resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the Senate in brief recess to present the resolution.
This is the West Virginia Legislature on the West Virginia Channel. This is a recording of the Senate's floor session from earlier today. There are 3 bills up for passage in the Senate today. Senate Bill 125, authorizing the DHHR to promulgate legislative rules. Senate Bill 214, adopting the Uniform Electronic Legal Material Act. And Senate Bill 321.
Senate will come to order.
Senate Bill
will come to order.
426.
The senator from Harrison.
Thank you, Mr. President. Mr. President, I request unanimous consent that the following resolution be taken up for immediate consideration and the committee reference be dispensed with, and that the resolution...
The senator from Harrison requests unanimous consent to introduce a resolution from the floor. Is there objection? Chair hears none. Gentleman may proceed.
Thank you, Mr. President. Today, Mr. President, we are
the clerk
here...
will read the resolution. I'm sorry.
Oh, thank you.
Yeah.
I'm sorry, Mr. President.
Senate Resolution 25 by Senators Romano and Facemeyer commending and congratulating Jeffrey Stutler of Harrison County as West Virginia's Outstanding Tree Farmer of 2017.
The question before the Senate is adopts the resolution. The senator from Harrison.
Thank you, Mr. President. Now I believe that I need to make the motion again. I apologize. Mr. President, I request unanimous consent that the resolution be taken up for immediate consideration, committee reference dispensed with, and that the resolution be put upon its adoption.
The senator from Harrison requests unanimous consent that the resolution be taken up for immediate consideration, committee reference be dispensed with, and the resolution be placed upon its adoption. Is there objection? Chair hears none. Senator from Harrison.
Thank you, Mr. President. If I may speak to the resolution. Today, we honor the Outstanding Tree Farmer for 2017, Jeff Stutler. Jeffrey Stutler hails from the great county of Harrison, which is the reason I get the honor of introducing him in this resolution today. Mr. Stutler owns a 315-acre farm in Harrison County, and he's committed to the West Virginia Tree Farm Program. That means he's made a commitment to sound forestry management practices, and that commitment will result in the improvement of wildlife habitat, water resources, timberlands, and recreational practices. It's the kind of farmer we need in West Virginia. Nominated by West Virginia Forester Jurgen Wildman and selected by the West Virginia Forestry Service, will you please congratulate and vote for the resolution for Jeffrey Stutler as West Virginia Outstanding Tree Farmer for 2017.
Question, further discussion? Further discussion? If not, the question before the Senate is adoption of the resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the resolution adopted. The senator from Ohio.
Thank you, Mr. President. I request unanimous consent that the remarks by the junior senator from the 12th be printed in the appendix of the journal.
Is there objection? Chair hears none, so ordered. Senator from Ohio.
Thank you, Mr. President. I move the Senate stand in brief recess for the purpose of presenting the resolution.
The senator from Ohio moves that the Senate stand in brief recess for the purpose of presenting the resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the Senate in brief recess to present the resolution.
The remaining two bills up for passage in the Senate today. Senate Bill 321, reporting requirements of employee information to the Consolidated Public Retirement Board. And Senate Bill 426, repealing the DNR legislative rule on litter control grant program. On second reading, the floor amendment stage in the Senate, Senate Bill 4, allowing licensed professionals donate time to care of indigent and needy in a clinical setting. Senate Bill 5, disqualifying CDL for DUI conviction in certain cases. That's commercial driver's license. Senate Bill 9, regulating unmanned aircraft systems, drones. Senate Bill 180, relating to the PSC jurisdiction over certain telephone company and internet services. Senate Bill 225, allowing magistrates to conduct proceeding for temporary emergency protective order dealing with temporary custody by family court. Senate Bill 236, relating to damages for medical monitoring. Senate Bill 261, relating to increasing salary or wages of judgment debtor. Senate Bill 337, hiring correctional officers without regard to placement on correctional officer register. Senate Bill 345, allowing hunting and trapping on Sundays. Senate Bill 346, relating generally to the jurisdiction of the Public Service Commission over motor carriers. And Senate Bill 347, relating to modernization of the Physician Assistance Practice Act. Those are the bills on second reading, the floor amendment stage in the Senate today.
Senate will come to order. Senate will come to order. Motions. Petitions.
There are none.
Unfinished business.
Senate Concurrent Resolution 23, naming the Johnny Odell Linville Memorial Bridge.
I'm looking for it, Lee. Yeah, I just didn't see it. Oh, here we go. I didn't even see it. Resolution will be referred to the Committee on Transportation and Infrastructure. Bills on third reading.
Engrossed committee substitute for Senate Bill 125, authorizing DHHR promulgate legislative rules. Third reading of the bill.
Question is passage of the bill. The senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 25 includes all of rules bundle number 5. There are 9 separate bills that make up this bundle, numbered originally SB 118 through, actually I think 126. The rules come from DHHR and the Health Care Authority. And so I'm going to go through the 9 rules that make up this bundle. I would tell the body these were not amended in any fashion in the Judiciary Committee. There were some amendments to a couple of the rules in Health, but all these rules have gone through the rulemaking process, the Committee on Health, and now the Judiciary Committee. Senate Bill 118, which is the first in the bundle, includes the DHHR rule codified at 64 CSR 103. This is a rule that comes as a result of the passage of Senate Bill 123 relating to expedited partner therapy in West Virginia. That was a bill we passed, and these are rules that follow that allow a medical provider to prescribe for both partners when one has a diagnosis of a sexually transmitted disease. Senate Bill 119 is a DHHR rule that relates to the licensure certification of clinical laboratory technicians. It's codified at 64 CSR 57, and it's got a new sunset date in it, and it updates existing regulations and rules. Senate Bill 120 is a DHHR rule relating to clandestine drug laboratory mediation. And so that was an existing rule, but it's been updated by the DHHR now, and it relates to meth labs and automobiles. The old rule didn't cover that. There are changes to the definitions, and licensing requirements updated for the remediation. People have licenses for that. Senate Bill 121 is a DHHR rule codified at 69 CSR 11, and this is the first of 2 really big rules. 121 and 122 are rules that have worked their way through the process now following the passage by the legislature of Senate Bill 454 last year. That was the governor's bill on medication-assisted treatment. And for those of us who were here, everyone would remember, but for those who weren't here, the governor's bill basically framed the idea that just giving people who have drug addictions methadone and Suboxone in those facilities and clinics without doing any other treatment wasn't doing them any favors, and wasn't really helping West Virginia in its efforts to curb this opioid abuse problem we have in this state. So Senate Bill 454, which was passed by this legislature, I think with a big, strong bipartisan vote, both houses, was designed to say, wait a minute, we're not just going to take people with heroin addictions and stick them in a methadone or Suboxone clinic and give them drugs forever. We're not accomplishing anything. So 121 and 122, which are part of this bundle, are the rules that were developed. And if I were to go through every provision of those rules with you, we would be here until Friday doing it, because they are an extensive regulatory regime, requirements now on what these clinics and facilities have to do to provide treatment, how they have to be organized, their licensure, it is, an extensive regulatory regime in both of those rules, one for methadone clinics, one for opioid Suboxone clinics. Okay, Senate Bill 123 is part of the bundle. It's a healthcare authority rule, and that is necessitated by the passage last year of House Bill 4365, and it relates to certificate of need. Members who were here last year remember we passed that bill, which made changes in when certificates of need are going to be required, and this rule now is the follow-up to that, changes the application process, the cost. Members will remember the old certificate of need, I think, had an application had to be submitted with a fee that was tied to the cost of the project. This rule now tracks the change we made in the law, which sets it a flat fee of $1,000. Senate Bill 124, which is codified at 65 CSR 30, is also a health care authority rule, and that's a rule that relates to the rural health systems grant programs. And it sets cap on those grants and loans of $50,000, allows variances under special circumstances, makes other changes in that. Senate Bill 125, which is part of the bundle, is codified at 65 CSR 31. It is also a healthcare authority rule, and that relates to the hospital assistance grant program. And again, establishes a cap on grants of $50,000. And the rulemaking authority from that flows from the healthcare authority. It makes changes to the rulemaking authority of the agency. Again, this is from House Bill 4365, which was last year. Senate Bill 126 is the final rule in the bundle, and it's also a healthcare authority rule, and it also relates to certificate of need. It's codified at 65 CSR 32, and it sets out definitions. This comes also from House Bill 4365, passed last year, the 2016 regular session. Requirements for obtaining a CON, a certificate of need, are set out, which mirror the statutory requirements, and bringing the rule that existed from the Healthcare Authority into conformity with the changes that were made in statute by the legislature last year. I'll be happy to try to answer questions, Mr. President. Otherwise, urge passage of this bill.
Further discussion? Further discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there being 32 yeas, 0 nays, 2 absent and not voting, more than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The senator from Ohio.
Thank you, Mr. President. I move that the bill be made effective from passage and request unanimous consent that the roll call on passage be used to make it so effective.
Senator from Ohio moves that the bill be made effective from passage and requests unanimous consent that the roll call used on passage be used to make it so effective. Is there objection? Chair hears none. On this question, there being 32 yeas, 0 nays, 2 absent and not voting, more than 2/3 of those elected having voted in the affirmative, I declare the bill effective from passage. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 214, adopting Uniform Electronic Legal Material Act. Third reading of the bill.
Question is on passage of the bill. The senator from Morgan.
Thank you, Mr. President. Senate Bill 214 is creates a new article in the West Virginia Code, and it is designated as Article 6 in Chapter 39, entitled the Uniform Electronic Legal Material Act. And it is, as the name suggests, a uniform act. It's one of the uniform acts that have been proposed by the Commission on Uniform State Laws and adopted by a number of states now. I'd never heard of this, but was contacted by a Professor Etheridge at the WVU College of Law, who made the case that this is something that the legislature should consider adopting. She's since left and is apparently teaching in Colorado, but she, I think, worked in the library at the WVU College of Law. And so it's a new article in the code, as said, Chapter 39, Article 6, and it has 11 sections. But it relates to the authentication of legal documents, legal authority, really. And so, and particularly with respect to the documents which are stored electronically. It establishes, it has short title, it has definitions in it in Section 2. It applies in Section 3 to all legal material in an electronic record that is designated as official under Section 4. And then Section 4 talks about how the official publisher, what the official publisher of the record has to do. Designate an electronic record as official, comply with the other sections of the Act, and then Section 5 relates to how you authenticate these legal records. Section 6 delineates the effect of authentication. Section 7 of the Act relates to preservation and security of legal material in official electronic record. Section 8 relates to public access. Section 9 are standards. And then Section 10 relates to the application, calls for uniform application of the Act. And then Section 11 relates to the interplay between this Act and a couple of federal acts, the Electronic Signatures and Global National Commerce Act, which is part of the United States Code. And one of the things this Act does is delineate who is the official publisher of certain legal documents. And so it makes clear that for the Constitution of West Virginia, the legislature is the official publisher. For the Code of West Virginia, the legislature is the official publisher. For the acts of the legislature, which are published annually or biannually, it's the West Virginia House of Delegates. For a rule published in the State Register, it's the West Virginia Secretary of State. And for a state administrative agency decision, it is that state agency. So, Mr. President, I'd be happy to try to answer questions. Otherwise, urge passage of the bill.
Further discussion? Further discussion? Not. The question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there being 32 yeas, 0 nays, 2 absent and not voting, more than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action of the Senate to the House. The Senator from Ohio.
Thank you, Mr. President. I request unanimous consent to return to the second order of business for the purpose of an introduction.
Senator from Ohio requests unanimous consent to return to the second order of business for the purpose of introduction. Is there objection? Chair hears none. Gentleman may proceed.
Thank you, Mr. President. Members of the Senate, we have with us in the rear of the gallery, or the rear of the Senate chambers here, a former member of the House of Delegates, Delegate Woody Ireland. If the Senate would please make him welcome.
Further bills on third reading?
Yes, sir. Engrossed Senate Bill 321, reporting requirements of employee information to CPRB. Third reading of the bill.
The question before the Senate is, shall the bill pass? The senior senator from the 8th.
Thank you, Mr. President. Senate Bill 321 amends Chapter 5, Article 10D of this code by adding a new Section 12 to the West Virginia Code. The bill is proposed legislation that comes to us from the CPRB. It proposes law that requires public employers who participate in the public retirement systems administered by the CPRB to report information to that board. The information must be reported in a prompt manner to the board, and that information includes categories such as personal identification, information about compensation, information about type of employment. I'm happy to try to answer questions, Mr. President. Otherwise, I urge passage of this bill.
Further discussion? Further discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there being 32 yeas, 0 nays, 2 absent and not voting, more than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The senator from Ohio. I'm sorry, I just thought. The clerk will communicate the action of the Senate to the House. Further bills on third reading?
Yes, sir. Engrossed Senate Bill 426, repealing DNR legislative rule on litter control grant program. Third reading of the bill.
Question before the Senate is, shall the bill pass? The senator from Morgan.
Thank you, Mr. President. The Senate Bill 426 is pretty easy. It's a simple repealer. It repeals a rule, it eliminates a rule that was effective as of April 14th, 2000, under the authority of the DNR relating to litter control. And the reason we're eliminating the rule is because that oversight was moved from DNR to DEP. DEP has its own rule. The DNR rule is obsolete and unnecessary. I urge passage of the bill.
Further discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there being 32 yeas, 0 nays, 2 absent and not voting, more than a majority of those present and voting having voted in the affirmative, I declare the bill passed. Senator from Ohio.
Thank you, Mr. President. I move that the bill be made effective for passage and request unanimous consent that the roll call on passage of the bill be used to make it so effective.
Senator from Ohio moves that the bill be made effective from passage and requests unanimous consent that the roll call used on passage be used to make it so effective. Is there objection? Chair hears none. On this question, there being 32 yeas, 0 nays, 2 absent and not voting, more than two-thirds of those elected having voted in the affirmative, I declare the bill effective from passage. Bills on second reading. Clerk will communicate the action of the Senate to the House. Bills on second reading.
Committee substitute for Senate Bill 4, allowing licensed professionals donate time to care of indigent, needy, and clinical settings. Second reading of the bill.
Are there amendments to the bill?
Yes, sir. Senator Takubo moved to amend the bill on pages 12 and 13, section 17.
The junior senator from the 17th.
Thank you, Mr. President. I ask unanimous consent to explain the amendment in lieu of having it read.
Senator from the 17th, junior senator from the 17th, requests unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none. Gentleman may proceed.
Thank you, Mr. President. The amendment is completely technical in nature and does nothing to change the nature of the bill. I urge adoption.
The question before the Senate is adoption of the amendment. Is there discussion? Discussion. If not, all those in favor will say aye. Those opposed, nay. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Further amendments?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 5, disqualifying CDL for DUI conviction in certain cases. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 9, regulating unmanned aircraft systems. Second reading of the bill.
Are there amendments to the bill?
Yes, sir. Senator Trump moved to amend the bill on page 6, section 5.
Senator from Morgan.
Thank you, Mr. President. I ask unanimous consent for leave to be able to explain the amendments in lieu of their reading and to have all the amendments considered as one.
The senator from Morgan requests unanimous consent to explain the amendments in lieu of having them read and that all amendments be considered as one. Is there objection? Chair hears none. The senator may proceed.
Thank you, Mr. President. The amendments contain both technical and some slight substantive changes. So the technical amendments include inserting some words that were dropped. For instance, the bill refers to publication. We're going to make it clear and add the words to the general public in that. adding a substantive change is we're adding a subsection in Section 8 to make clear that the offenses delineated in Section 3 are not going to be affect or cover, are not going to cover a person holding a valid commercial license for purposes of news gathering if the operation of an unmanned aircraft system is in compliance with all the applicable rules and requirements of the Federal Communications Commission and the Federal Aviation Administration, and it doesn't violate the provisions of Section 3. We're inserting a comma after the word police and reinserting the West Virginia Sheriff's Bureau for Professional Standards, which we'd taken out of the bill because we weren't sure that it was still functioning, but it is, and it needs to be in there. Mr. President, I'd be happy to try to answer questions, urge adoption of the amendments.
Question for the Senate is adoption of the amendment. Is there discussion? Further discussion? If not, all those in favor will say aye. Those opposed, nay. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Further amendments to the bill?
Yes, sir. Senator Prezioso moved to amend the bill on page 4,
The Senator
Section
from
3.
Marion.
Thank you, Mr. President. I ask unanimous consent to explain the amendment in lieu of having it read.
The Senator from Marion requests unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none. The Senator may proceed.
Thank you, Mr. President. The way the bill currently reads is that individuals owning a drone or an unmanned flying machine can't fly a drone on their property when it's within 100 feet of another person's house. This amendment simply clears it up and says that if you own a drone or an unmanned flying machine, you can fly it on your own property regardless of how close you are to your neighbor's home. In the neighborhood that I live in, that's problematic, where you have homes that are in close proximity of each other, and our neighborhood is children friendly. It's not unusual to have children running in and about the houses and throwing a football, kicking a soccer ball, playing football, or even driving these cars that are electronically controlled. So what this bill does, it simply says that if you own a drone or an unmanned flying machine, you can fly it on your own property regardless of how close you are, or you can fly it if you have permission within a neighbor's proximity. It simply makes it available to fly these things on your own property regardless of how close they are to your neighbor's property, and I urge the adoption of the amendment.
Further discussion? The Senator from Morgan.
Thank you, Mr. President. The amendment offered by the Senator from Marion County improves the bill. It clarifies that issue in a way that I'm glad he was able to figure out a way to do it better than we had done it, and I'm happy to join in his motion that the amendment be adopted.
Further discussion? Further discussion? If not, the question before the Senate is adoption of the amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Further amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 180 relating to PSC jurisdiction over certain telephone company and internet services. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 225 allowing magistrates to conduct proceeding for temporary emergency protective order dealing with temporary custody by family court. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 236 relating to damages for medical monitoring.
The Senator from Ohio.
Thank you, Mr. President. I request unanimous consent that the bill be advanced to third reading with the right to amend.
The Senator from Ohio requests unanimous consent that the bill be advanced to third reading with the right to amend. Is there objection? Chair hears none. So ordered. Bill will be engrossed and advanced to third reading with the right to amend.
Committee substitute for Senate Bill 261 relating to increasing salary or wages of judgment debtor. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 337 hiring correctional officers without regard to placement on correctional officer register. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 345 allowing hunting and trapping on Sundays. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Senate Bill 346 relating generally to jurisdiction of PSC over motor carriers. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 347 relating to modernization of Physician Assistant Practice Act. Second reading of the bill.
Are there amendments to the bill?
Yes, sir. Senator Takubo and Stallings move to amend the bill by striking out everything.
The junior senator from the 17th.
Thank you, Mr. President. I ask unanimous consent to explain the amendment in lieu of having it read.
The junior senator from the 17th requests unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none. The senator may proceed.
Thank you, Mr. President. Again, this amendment is technical in nature only. Urge passage of the amendment.
Further discussion? Further discussion. If not, the question before the Senate is adoption of the amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Are there further amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced to third reading. Bills on first reading?
There are none.
Introduction of guest. Introduction of guest. Remarks by members of the Senate. Remarks by members of the Senate. Miscellaneous business. The senator from Ohio.
Thank you, Mr. President. Subject to announcements, I move the Senate stand adjourned until
The senator from Ohio.
Thank you, Mr. President. I move that leave of absence be granted for the senator from Greenbrier.
The senator from Ohio moves that a leave of absence be granted for the day to the senator from Greenbrier. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the motion adopted. For what purpose does the senior senator from the 6th seek recognition?
Mr. President, I would like to return to the 11th order of business.
The senior senator from 6 requests unanimous consent to return to the 11th order of business for the purpose of introduction. Is there objection? Chair hears none. The senator may proceed.
Thank you, Mr. President. On behalf of myself and the senator from Mercer, I would like to welcome our page, Andrew Rife's father, Cliff Rife from Bluefield. He's in the North Gallery. Cliff, please stand and Senate make him welcome.
The senator from Ohio.
Thank you, Mr. President. Subject to announcements, I move the Senate stand adjourned until tomorrow at 11 a.m.
Are there announcements? The senior senator from the 4th.
Thank you, Mr. President. The Senate Finance Committee will meet at 3 p.m. We have Health and Human Resources up there today.
The senator from Monroe.
Thank you, Mr. President. Your Committee on Education will have a meeting this evening at 2 in your finance room. Thank you.
The senator from Morgan.
Thank you, Mr. President. Your Committee on the Judiciary will meet today at 3 p.m. in the Judiciary Committee room in the West Wing.
The senator from Tucker.
Thank you, Mr. President. Your Committee on Energy, Industry, and Mining meeting has been canceled today. There will be no meeting at 1 o'clock today. Thank you.
The senator from Preston.
Thank you, Mr. President. Your Committee on Agriculture will meet tomorrow at 2 p.m., 208 West.
Further announcements? The junior senator from the 17th.
Thank you, Mr. President. Your meeting on Health and Human Resources will meet today at 1 p.m. In room 451M with full agenda. Thank you.
Further announcements? The senior senator from the 8th.
Thank you, Mr. President. Your Committee on Government and Organization will meet at 2 p.m. today in 208 West.
Further announcements? Further announcements? If not, the question before the Senate is, shall the Senate stand adjourned until tomorrow morning at 11 a.m.? All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the Senate adjourned until tomorrow at 11 a.m.
A recording of the Senate floor session from earlier today. We will be back at 3 o'clock for a meeting of the Senate Finance Committee, a budget presentation for the Department of Health and Human Resources. Until then, I'm Beth Voorhees for the West Virginia Channel, a service of West Virginia Public Broadcasting.